Court officer. Court officer.
I may make a mention, my lords. My lords could recollect one contempt petition in the case of an interim custody where there was a Supreme Court order of stay on the lower court proceedings. My lords had said to get a clarification. My lords, the Honorable Supreme Court last Thursday, passed an order that the High Court, that order should not come in the way of the High Court proceedings. We have not, so therefore I'm seeking to move the matter for tomorrow. We have not yet, the order has not been uploaded. The affidavit of the advocate on record is being filed to that effect. The Honorable Supreme Court, in fact, heard both parties. Both parties.
So by the time order will...
But the urgency is that already the mother who's actually supposed to hand over custody as per the orders of the family court, she is making steps to in fact take the children out of the country. In fact, they have a Portuguese passport, and those we have come to know this is the information. So my lords, we don't want the matter to be infructuous. Tomorrow, my lords.
I would like to hear the order of this, text of the order.
Monday, my lord. Can I take a chance for tomorrow in case I get the order by end of day?
To get the order, you can again tomorrow mention.
Very. Otherwise, let it be on Monday.
Monday. Otherwise, Monday.
Great.
For posting, the deputy commissioner has confirmed the petition entries and also response. And the single learned judge, the petition, they have also confirmed the order of the deputy commissioner. Here it is for the admission.
It will be posted once you remove the officer.
But there is no office objection.
Then
they are trying to elevate the property.
After 10 days.
So this is a matter related to coal mining operation, Your Lordship. A base price was fixed in the year 2017. There was no escalation till today. I've made multiple requests, Your Lordship, and I'm under financial crunch. That's my urgency, Your Lordship.
After 2 weeks.
Kindly.
2 weeks. Any day after 2 weeks.
One matter for posting, Land Tribunal has granted occupancy rights to the appellant herein. That order has been challenged by me before the learned single judge.
Land reference.
Land Tribunal order, my lord. Occupancy rights has been granted to the appellants. That order has been challenged before the learned single judge. That writ petition has been allowed. Now the same order has been challenged before this honorable court. Therefore, matter may be posted on.
It will come in normal course. Once you remove the office objection.
All office objections have been removed, my
Then
lord.
don't accept this memo. Yeah. It will be listed. Yes.
The Tahsildar, has not passed the order. You know, specific direction given by the learned district judge. The matter has to be completed within a period of 6 months. But even after 3 years, the Tahsildar has not passed the order.
It will come in use court. No, no acceptance of that. Yes.
Last 3 years.
It will be listed. It will be listed. No.
On behalf of department on some departments approached the NCLT. NCLT has passed the order in 2020, my lord. Since state government or union that as per NCLT order, the recovery is not going on, my lord. The department is suffering.
After 2 weeks. After 2 weeks.
Lordship, filed an application, appeal 28, that is KDB has filed an appeal. In fact, the respondent number 1's land has been acquired by the KDB and parallelly by the National Highway authorities. The land has been utilized now without passing an award and depositing any compensation amount. My land has been utilized. I made an application seeking a direction.
After 10 days.
Please.
Lord, filed the public interest litigation, my lord, where KIDB has formed a layout and certain area is earmarked for park. Now they are allotting it to somebody else, my lord, as an industrialist.
Once you remove
the trying
once
to take possession.
Remove the objection to list.
Office objection
No,
removed, my lord.
Will not accept the memo for listing.
Kindly.
It will automatically listed. Yes.
One matter for preliminary hearing. The 28-1 has been issued under the KDB, my lords. Till today, my lords, even after the lapse of 26 years, final notification has not been issued.
Lords, learned trial, single judge has dismissed the writ petition. Lords, in the connected matters, my lords, where the learned single judge has held that the acquisition proceedings has been lapsed, my lords. Lords, one writ appeal.
The connected proceedings are coming up when?
My lords, connected proceedings, my lords, those, the KDB has not challenged those proceedings. my lords.
After 3 weeks. Yes, yes.
Serial number 54. Take for 2 days. Had a Monday. Had some difficulty going to. Monday. 24 meter.
270. We read appeal 270. Next Thursday. After 2 weeks.
Lords,
Lord, may I make one
serial
submission?
number 35, sir, writ appeal by His Lordship Justice Krishna Dikshit's order, my lord, serial number
Peter,
35.
I represent Union of India Manors.
So give the number, not to be placed before the bench.
Tell them to look into this one, again posting it. By protocol, they come here.
Grateful, my lords.
Similarly, my lord, serial number 32 also. Your lordship is.
32.
Wherever it is there, same order.
Same one.
Lord, serial number
Without
53,
saying.
my lord. May I make one request now? Serial number 53, my lord.
For that you need not mention.
Noted.
My lord, may I make one submission? Serial number 53, my lord.
2 weeks.
My lord, I have some personal inconvenience today, my lord. May I request your lordship to have it on 27th?
3 weeks, sir.
3 weeks.
My lord, 53, my lord. My lord, today I am having some personal inconvenience, my lord. May I request your lord?
Sir, please wait, sir. Physically, they are mentioning.
Make use of the mic.
Sorry, Your Lordship. Your Lordship, serial number 11.
It survives.
Kindly have it.
Election,
next
election
week.
to occur.
Will
Election
not
in the,
survive at all. Will it survive? Have you taken any contention as to even after election, this matter will survive?
elections are over.
Your Lordship,
Elections are over.
Oh, my senior is out of town, Your Lordship,
Next
to
Wednesday.
take instruction. Kindly have it next week. Your
Take
Lordship.
instruction whether this will survive or not. Next Wednesday.
Please, Your Lordship.
Serial number 47, Your Honor, prays for a short accommodation.
40.
47,
40.
47.
47. After vacation.
Also bless.
May I make one submission, my lord? My lord, serial number 53, my lord.
Serial number 44 in the matter.
44.
In the preliminary hearing.
44.
Yes. And the matter may kindly be taken up after 4 weeks, please, my lord.
That is that
Lekanti.
second April. 2nd April.
2nd April.
We have posted similar matters on 2nd of April. On that day, this matter will come along with rest of the.
Sir, anybody mentioning through
Yes,
VC,
sir.
sir?
Lord, serial number 53, my lord. My lord, I have some personal inconvenience today, my lord. May I request your lordships to have it on 27th, my lord, next Wednesday, my lord. I will be obliged, my lord.
You are not audible, Mr. Counsel.
My lord, now, my lord.
Sir, Prabhakar Rao, you are not audible properly, sir. And also, you are not visible, sir.
Come at 2:30. for
My
now.
lord, I have some personal inconvenience, my lord. May I request your lordship to have it.
You want time, then we'll be giving the time.
He wants time.
Non-compliance of office objection, second time, seal number 1, Mr. Ravi HK. Ravi HK.
2 weeks.
Lord, this matter was disposed of on merits on 28/2/2023, my lord. 28/2/2023. However, the matter is listed on office objections.
Disposed of this matter. No, it's disposed of.
All. Just check.
Disposed of.
We got the record how we got this.
Dismissed.
It was dismissed.
Yes, dismissed. Since this repeat, in recall. Is it recalled? Did you make any application for recall?
But earlier it was dismissed for non-compliance of office objection.
Thereafter on
On the
merits
very
it
same
is.
day, it was recalled and disposed of on merits.
After recall, he says one more order has been, judgment has been dictated.
On which date it was disposed of?
28/2/2023, my lords.
29/2.
28/2.
28/2. 24.
28/2/2023.
Same day.
23.
Very same day.
23.
23, my lord.
Oh.
23.
Just to fit market.
May I pass on the copy of the order?
The order is also there.
Yeah, these also. Dismissed. Good. This, this petition was dismissed by a coordinate bench of this court while order dated 28 February 2023, and therefore no further orders need be passed. That's true. Order need be passed.
Seal number 2, Mr. Munesh Kumar KV.
Appellant in this matter, madam. I pray 2 weeks of time to
This is
comply.
also part of group. Competency of the deputy commissioner. Some matters are kept. You want time? 2
I
weeks.
pray 2 weeks of time.
2 weeks time is granted to remove the office objections.
Much
Telling with the appeal shall stand dismissed without reference to or order of the court.
Seal number 3, Ajay Jain.
Complied, four objections are raised, my lords. One is regarding stating of correct provision. We have now stated it, my lords. Then, my lords, copy to be served to KIDB, we have served it, my lords. Then, my lords, there were 2 writ petitions, my lord, in respect of which common orders were passed. We've challenged one in the WA 5359, my lords, and other one in WA 395, my lords. My lords, the office objection is that both sets of papers must be filed in each appeal. That is the objection which is raised in 359 because it's filed in both. My lord.
So now removed.
My lord,
Learned counsel says that the office objection is removed post after 2 weeks.
my lords, there is some urgency, my lords. My lords, in fact, matter was stated for today. The other side requested us for 1 day's accommodation, my lords, because Mr. Raghavan was unavailable. He personally called me and requested, my lords, matter may be had tomorrow, my lords, because there is a deposit amount which has been ordered to be deposited, and that amount has to be released in favor of.
Correct, but within 2 weeks, what will happen? It will be released, considered after 2 weeks.
My lords, we request, my lords, please, my lords, the ASG was ready to appear, my lords, because Mr. Raghavan made a personal request saying 1 day accommodation they wanted. That is, but please, my lords, please, my lords. Monday.
No. Monday there are, next Monday. 20, it will be what day, which date? 1st of April.
Seal number 4 for third time, Mr. Gopalakrishna R.
Nobody is there.
Copy is also not.
Only objection is 12 rupees court and representative we consider. 2 weeks.
Number 5, Mr. Pradyumna L. Narasimha.
Allows the appeal for the appellant, my lords, 2 weeks time allows to remove the office objection.
Or like 2 weeks.
Oblige, my lords.
December
Same-
6,
same- You pass the same order. Failing with the,
December 6, Mr. Anil KS. December 6.
You would like to place on record that his suspension, my lords, of the petitioner.
we are aware.
The order
Counsel
dated-
for the petition appellant.
Counsel for the appellant, order dated 3rd February 2024, my lords. In fact, your lordship may have to inform the registry about this insofar as his listing of his matters are concerned in all courts, my lords, in view of his suspension, my lords.
Suspended on that eventful day or earlier to that?
3rd February, my lords.
3rd February only.
3rd February itself.
Or the order was communicated to him? Yes,
Uh,
it was communicated also.
13th February, my lords. It was 13th March, it was signed, my lords. I'm sorry, we should be 13th March, my lords. So your lordship may kindly inform the registry about this in wherever his matters are listed, my lords, so that.
Normative procedure is that the registry has to send a notice after deleting his name.
Please.
But he is not here.
So therefore, my lords, let the registry, he may not be here, my lord. He cannot be here also, my lords. One other aspect, he cannot be here also
No, no,
because.
he has to be here because he has made an allegation against one of us saying that one of us is responsible for filing of the pendency.
Your lordship-
Although I have been a judge since last 6 years,
Your
pendency is there since about
Sir,
35 years.
I am appellant through VC, sir.
Uh.
Serial number 6.
Yes.
Serial number 6, sir. I am unwell today. And I am suffering from a cold, cough and running nose, sore throat and etc. I have filed one memo, sir. Memo on 18. Please see the memo, sir. I have filed a detailed memo.
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 One more memo you have filed now.
Yes, sir. I have filed in counter, sir.
Yes.
When
Police,
what is this? Writ
requirement.
appeal. Writ appeal comes up for consideration. From figures in the record of the appeal. A Xerox copy of notification number 32 of 24 dated 13th March 24 of the Karnataka State Bar Council, which reflects that the disciplinary.
Sir, that notification itself an illegal, sir.
It's all right. Hello, we are writing the order. Yes.
Without hearing me,
Without hearing
without
you, we are
following
writing this order based upon the record. You need not.
these are all in the High Court conspiracy.
All right.
Kindly listen the order.
Listen to the
Then
order,
react.
sir. Don't interfere.
Kindly listen
Yes,
the
sir.
order, then
Your
react.
lordship may kind of silence
Passed by
him.
the disciplinary
Mute-
committee
Mute it, you not listen to
of
what
the
he
Bar
saying.
Council,
People should
which
know.
show that
Public should know what kind of people
the
we have.
respondent, that's Sri Anil KS, son of Sri Swami Gowda, KJ, advocate, Then write down the address KAR/1037/2017, number 1931, Gavipuram Post, Bengaluru 560019. Who is the advocate for the appellant? Is subjected to suspension of subject to suspension from practicing as an advocate. And he is further directed to refund the amount of rupees 2,45,000 with interest of 12% by way of punitive damages payable to his client forthwith. Full stop. In course of the hearing of the matter, Sri Anil KS appears through video conferencing to submit to the court that he is in indisposed health, therefore could not remain physically present. He therefore requested to defer the consideration of the matter. Full stop. The request is exceeded to. When do you want? Mr. Anil, when do you want? Which date do you want?
Yes, muted.
Please unmute yourself. Unmute yourself.
He will not.
Sir, please, switch on the mic, sir. You are muted, sir. Please unmute your mic.
Please,
No
one
judge will
signal.
be able to do the job.
Unmute yourself, Mr. Advocate.
Mr. Anil KS, please unmute your mic, sir.
He will not.
You are not audible, sir.
Is extended to?
Your Lordship may kindly give a date.
So
And-
the appeal may be posted on, shall be posted next on 16th of April. In the meantime, the Registrar General of this court is directed to seek confirming instruction with regard to the details as above, figuring on record about the notification suspending the.
And one other thing, Your Lordship. Your Lordship may kindly take note of the earlier judgment of this honorable court as well as the order sheet maintained by this court, the observation made by this court, maybe kindly think and communicate it to him also. We'll see that it is the registry has to communicate to him.
Citizen Learned Advocate General, Mr. Sasikiran Shetty, invites attention of the court to the various orders passed
Please.
in the proceedings, which reflect on the conduct of the
Please.
advocates, the KS and it, then all those things. We have acceded to your request and kept the matter on 16th of April, Mr. Anil, and we are confirming what is stated in this, what is stated in the notification through Registrar General. Right?
We should not achieve. Need to be very sternly dealt with, if necessary, by imprisonment.
In his presence, we'll do.
Yes.
He'll do. That
Otherwise,
would be it.
tomorrow, this is the only institution. We may err in our judgment, but this is the only institution which will save this system. Beyond this, we will not say.
Absolutely.
He is able to listen to us.
He is able to
He will be
listen, my lord.
listening everything.
He
Listening.
understood
Yes.
everything.
Next
my
date
lord.
we will do.
So 16th, Mr. Anil, you kindly remain present so that we
Can I
you
make
can
one more
submit
request,
whatever
my
you
lord?
want to submit.
Today's order sheet may be sent to him through the registry of my lord.
Yes,
That
the
is very,
present order shall be transmitted to Sri KS Anil by the registrar.
please, my lord.
Will be the copy of copy of this order shall be forwarded to Sri KS Anil by the registrar
I'm grateful.
for information.
Please.
In fact, Bar Council has recorded that he has taken 2,45,000 rupees from an ex-serviceman to conduct the case, and he has retained that money without conducting the case. If such persons are to be treated as the full-fledged members of the bar or bar council, then just think about that also. Tomorrow, no judge will be coming forward unless all of you come to our rescue. Please bear this in your mind. We are absolutely fearless. And perhaps you are aware of that also. But unless such people are treated sternly in accordance with law, then protecting the independence and efficacy of the judicial institution will be very difficult. Therefore, all quarters who are here, many senior advocates are here, and many tall members of the bar are here. Kindly bear this in mind. This is very important. This is the only institution which will protect you. No other institution, perhaps, arguably, this is what Nariman says in his Before the Memory Fades. Kindly bear this in your mind. Deliberately has done that. We should not leave him that way. We have to take risk tomorrow. Respect of the bar, respect of the bench will not be. People think that all advocates will be like this only. A very few such people. Otherwise, our bar, whichever judge comes to our high court from other state, always they shed tears when they leave our court, when we give them send off. But I'm not just saying this. This bar is a unique bar. Even where death penalty is given, counsel for the appellant will say he will make salute, he will salute and leave the court. This is our tradition. Very tall members of the bar. Very. Yes.
For 10th time, still number 7, Mr. M.V. Charity. Subjection for 10th time.
Respondent 1 by me.
Lordship, 1 week's time, Your Lordship.
2 weeks. 2 weeks.
Please.
Same.
Still number 8, Sumoto writ petition.
I am the amicus appointed with this honorable court to represent the honorable high court. The registrar general is the party before this court.
They had not taken that. Therefore, time was fixed. Now we have to ascertain whether the consent of those people from that particular part of this function.
So additional posts will be created.
They said they would create and fill it up within the time frame.
Yes.
But I don't know what they have done so far.
My lords, I have received certain instructions. On 13/3 of this year, my lords, the KPSC has invited applicants for filling up 92 posts amongst other posts which are required from the BBMP. My lord. I should place that notification on the next date of hearing. I just been informed about the same.
This order was made on 9/10/2023. Kindly see the language of the order. Yes, little acidic it is. And now you are saying you don't have notification also. This is a PIL and so motor registered matter.
Yes, my lords.
Then how to work?
My lords, I appear for BBMP.
BBMP?
Yes, my lords. KPSC is the one which was to conduct the recruitment process.
Correct.
I'm only informing the court that the KPSC is.
No, all information was required to be given to the KPSC when it was given, because this order was made on 9/10/2023.
Yes, my lords.
You can't just go on like this. Otherwise, a lot of time will be wasted in the court. What you have done for giving information will not give time.
My lords, the information was immediately given to the KPSC.
When it was given.
I will place that on record on the next.
Again, time.
No, we are only hoping that they'll give out a notification for recruitment. We've been informed that on 13/3, the KPSC has issued a notification inviting applicants. That is my information and which I wanted to submit to the court, my lords.
Thereafter, what they have done. Otherwise, we will be passing order after order in futility, to say the least.
Lord, some responsible officer of the cadre
That's
of
what.
secretary, principal secretary, or even the chief secretary can come and
Yes, he's right. Because he is secretary of all the departments under the rules.
In case if those information is got, my lord, then my last can proceed. Otherwise, if the information is not got, then I'll leave it to my lord.
Lord, corporation doesn't have the information. The state government, which is required to make the recruitment, it doesn't have the information.
Who is for you are for KPS. KPS is not a party here. BBP has sent out the information immediately, my lord, so as soon as this order was passed.
We should have done that.
So we will be taking, communicating with the KPS. You will be?
Again, this is the chief secretary, letter which I have given to chairman, and that I have received a response. Not exactly 2 weeks time, let me see what I do.
In light of the order dated 9/10/23 and the observations and directions passed therein, it is considered appropriate that the Karnataka Public Service Commission is arraigned as party respondent. Obliged. In the proceedings. Full stop. The petitioner is directed to carry out the amendment in the post title to join the KPSC through its secretary.
Who is the counsel? No, secretary.
Secretary.
By secretary. Who is the counsel appearing? Generally appears for panel counsel.
Notice shall go to the newly added party, returnable on which date? 15th of April? 15th of April. 3rd of April.
Yes,
It will be open for the learned amicus curiae for the amicus curiae appearing in the matter to show copy of this proceedings to learned counsel who normally appears in this court on behalf of the Karnataka Public State Service Commission. Full stop. On the next date, the KPSC shall respond to the court as to what action the KPSC has taken pursuant to the observations in the aforementioned order.
Lord, to carry out amendment, I may have to engage somebody else because nobody is on record for this.
No, you can direct that since it's.
We'll direct the course title shall be carried out, amendment course title will be accordingly carried out with registry.
Good job.
My lord, mine is a connected PAL.
It will go.
I want to brief on this.
Along with this.
No, there is a slight difference is there in my PIL.
Including the Public Service Commission.
KPSC is necessary.
No.
Because without hands, there is some variation in your matter.
Just
Is
hear my
true.
point. Just hear my point. Say they have given the affidavit to the court about a list of buildings which are not got the sanction. So in my case, I went to the appellate tribunal and got the order from them. Even then, I've been following up for the last 4 months. They don't take any action. And you have given them 80 engineers thing. On 8th of October, 80 engineers have joined. Even then, they don't take any action. I met the chief commissioner. I spoke to the journal commissioner. They don't take any action. I got a specific order from the Karnataka Appellate Tribunal also about that thing, upholding the 321(3) order. and the building is allowed to construct and it is almost complete now. If he sells it to other people, what will happen to the public? I can give a specific, that order also I can pass it on the Karnataka appellate tribunal.
Next, we are fixing very short date now, that KPSC also, come, we'll consider it.
Thank you.
Sir, please, there is some internet issue, sir.
Yes.
Serial number 6, regarding serial number 6. Sir.
It's over now. Yes, next.
It's over.
Yes.
Serial number 9.
Please, my lords, if you have the petitioner.
Please see my memo, sir.
This is a petition in public interest before an account of the commercialization.
Serial number 9 is called, sir.
So this petition deals with the rampant commercialization of a purely residential area in the Ward 58, HF 3rd stage in Bangalore. By an order of 15th March 2021, this honorable court had directed that a spot inspection take place. That inspection was concluded. Reports were filed by the BBMP and BDA, which virtually affirmed the contents of my petition. Since then, my lord, the BBMP has sought time to file its objections, but no objections have been filed.
May my lords pass on the progress report, my lords.
Not filed. Objections have not been filed.
Objections have not been filed, my lords. I am filing a memo with respect to the notices that have been issued to all the commercial establishments to.
But you took time to file objections, not memo.
My lords, memo
That
of
too very
compliance,
reluctantly, the
in
time
part
was given.
compliance, in part compliance of this order of this honorable court, my lords, we have closed down a few establishments, and also through an auto rickshaw, we have given public announcement to close down the shops within 7 days. Or action would be initiated as per the order, reissued notices on 11/3 and 6/3, my lords.
Can you file your objection?
Please, my lords.
We know that. They will not file. In our state, the bureaucracy does not work that way. So we used to levy.
If I may kindly permit to place this on record, my lords would be in a position to appreciate.
We are very sorry. This is the first court of the state. See the text of the order dated 2/1/2024. We are not here to please anybody. Where the court makes an order and you do not comply with the order, what we should do?
Apologies, my lords. I wanted to place on record the compliance.
Even court's orders are not respected. We are very sorry. Because everything is online, people will know about you. If we say, if you invite more comment, then
I put on, my lords, I'm only trying to place on record.
Why you are not filing
the
reply?
Compliance, my lords.
To answer why you are not filing reply.
My instructions were, since the compliance was being
There
implemented.
is an order of the court.
Please.
On 26th and 23rd.
My apologies, my lords, I bowed down.
Repeated on 2/1/24, requiring to file reply. Whatever reply counter you want to file, you have to file.
Please, I shall do that in a week's accommodation.
So
within a week.
File by Monday.
Positively,
by Tuesday.
Please, I shall do that.
Despite 2 orders and the directions given in the order.
which there should be default order. Otherwise, they will not, this time will be wasted this way.
My lords, in 2 days accommodation, I'll file.
We know you, we know you.
My lord, in fact, in our petition, we have said
what is possible.
We are only complying with the orders of this honorable court, my lord, so I felt it necessary to
Despite
bring
2
it to my
orders
knowledge.
earlier passed on 26th and 23 and 2/1/24, directing the, which is the respondent?
Respond BBMP.
Respondent number 1 BBMP to file statement of objections from our learned advocate Mr.
Karthikeyan.
Karthikeyan for BBMC. Was entirely at his receiving end when confronted as to why the reply public objections, statement of objections has not been so far filed. Full stop. We prayed for time. Full stop. No further time could be granted. Except up to 26th March, on which date the BBMC shall place on record its statement of objections. Please. Full stop. It is made clear that if the BBMC remains non-responsive in this regard, not only the court shall view the conduct sternly, but the cost will follow.
Good.
Whatever you want to file, but you file.
Please,
Then
please.
file.
Case number 10, Mr. Naveed Ahmad.
Your Lordship, I am appearing for appellant, Your Lordship. Last week, the matter was posted. I have to file the affidavit. Affidavit is ready, Your Lordship. I am just waiting for my client to be. Last time, I had taken a time for 2 weeks, Your Lordship. I had requested the court for 2 weeks.
By 12, by 1 is over, by 2 is over, by 3 is over, shortly by 4 will come.
When you will file? Last time.
I'll file within a week time, Your Lordship. My client is mostly, he will be coming on 20th of this 25th of this month, Your Lordship.
Which one?
25th of this month. So after next week.
Where from he comes?
He's from Mangalore, Your Lordship.
Bangalore.
Mangalore.
4 months.
Please, Lord.
Nearly 4 months for filing the pro forma affidavit.
No, Your Lordship, he was not well. He was admitted. If the Lordship wants, I'll file the documents also, Your Lordship. He was admitted in the hospital. He's the aged person. Finally, a week's time may be given, Your Lordship.
But when you will file now?
I'll file it within a week, Your Lordship.
Within what time?
Within 1 week of time,
1 week.
Please, Your Lordship. Please, Your Lordship.
At the request of learned counsel, Mr. What is your name? Mohammed Tahir? No.
Muhammad Sultan, Your Lordship. Naveed Ahmad. Please, Lordship.
Naveed Ahmed for the petitioner, for the respondent, sorry.
For the petitioner, Your Lordship.
So, time is granted up to 2nd February to file the affidavit. 2nd February.
Second
Sorry,
April.
2nd April.
Please, Your Lordship.
Really, which petition stands rejected?
The affidavit is not filed before the next date. Petition shall stand dismissed on the said ground alone.
Number 11 urgent, number 12, Gopala Krishnamurthy.
Appellants. I've served the end summons to the respondent number 8, Millard, and the last occasion. Now he is on record, Millard, has filed Okala. And now, Millard, they have served the copy and one of 24 for additional evidence they want to place on record. I will file my objections. 2 weeks may kindly be account.
You are for?
I am for the appellants, Millard. Please.
29 to 24. You were the petitioner before the court in the.
No, Millard, I am for the respondent.
Respondent.
Respondent. Please.
I represent respondent number 8. I filed my Okala yesterday. I need to file my objections.
Please.
may be permitted to file my objections.
By permission, you are entitled to do it under Rule 21.
2 weeks. Kind
2 weeks, 2 weeks.
Grateful.
Number 13.
Appear for the appellant, my lord. Lord, on the last occasion, we submitted to your lordship that during the pendency of the writ appeal, respondent was reinstated, my lord, and he is being paid 81,000 rupees salary. Current wages we are paying, my lord. At that point of time, my lord, your lordship suggested, your lordship gave direction to both the sides. Your lordship gave me direction to quantify the back wages in terms of the order. And my learned friend has orally submitted that he would forego 50% back wages, and he would file a memo to that effect.
Filing before your lordship.
No, both you have agreed for amicable settlement.
Yes, your lordship suggested 50%. I agree, your lordship. And I have prepared the calculation also, your lordship. That is what your lordship directed last time. The management should
May I
prepare.
make one request, my lord? May I request your lordship grant me short accommodation, my lord, for this calculation is almost ready. 2 or 3 days time I can give you that.
What calculation? We are not calculating the distance between earth and moon. We are calculating the back wages. All factors are with you.
10 years, my lord, calculation. My lord, I request for short accommodation. In fact, I could not secure senior counsel also. Mr. Nagarand had appeared on the.
All right, that's not the point.
He is on
For
his-
settlement only, you are concerned, we are concerned with you. Other day, we suggested that 50, my lord, the Honorable Chief Justice suggested. No, again and again, we will not give time. Court is not meant for giving adjournment. See what the people are speaking about us.
At least,
Please.
Case could be passed over, my lord, Mr.
Pass
Nagarand.
over. Pass over.
Pass
It
over.
will not happen.
Tomorrow, my lord. Tomorrow, my lord.
Only tomorrow.
Tomorrow.
Tomorrow will either way decide the.
Very well.
Unless you agree, of course.
Very well.
Tomorrow.
Sir, in sir. Issue is there.
That is over on, it is kept awaiting your physical presence on whatever date it is kept, when it is kept.
Number 14, Mr. H.L. Pradeep Kumar.
Serial number 14.
We'll conduct in your presence, Mr. Dhanesh. Not now. It is already adjourned. Order is passed.
Serial number 14, my lord, I appear for appellant's counsel. My lord, application is filed seeking vacation of the interim order. This order was granted by the Honorable Court after hearing both parties on 2/11/2023. Matter has been admitted and Lord, the order was to post the matter for hearing. In fact, the matter was listed for hearing also. It did not reach, my lord. We will file objections, my lord. to
Can I
the
make a
IA.
submission, my lord? My lord, this is a matter where preliminary notification was issued in the year 2011, which is only a proposal under the KIDB Act. The final notification thereafter issued, my lord, in the year 2013, 2011 was quashed in an earlier round of litigation by this honorable, by the learned single judge of this honorable court on 26/2013. And KIDB was directed, my lord, to take a decision whether they require my land or not for the purposes of the cricket stadium by the BCCI. Thereafter, my lord, till 2022, for 9 years, the KIDB did not take any decision. And I was constrained to file this present writ petition. And in the writ petition, my lord, the cricket board, BCCI said, I don't want the land. KIDB has told the court that I've written a letter to the state government saying I don't want the land. KIDB's position before the learned single judge was, I don't want the land. It was on that basis the writ petition came to be allowed. BCCI themselves said that we don't want the land. My lord, I'm a senior citizen. For 14 years, my lord, Honorable Justice Krishna Dixit's judgment, my lord, in the case of Shantamma, where my lord was pleased to hold the value of the right of a person insofar as property. And keeping this, my lord, for...
But this order was passed after hearing you.
2/11
requires hearing.
I'm not...
Fix a date for.
My lord was pleased, on the earlier date also, my lord was pleased to say that a date be fixed, my lord.
In fact, my lord, this issue is pending before the apex court, my lord. In fact, in one case, the Indian bench has taken the view that In case of acquisition for a public corporation, if reasons are available for the delay, acquisition should not be quashed.
No, the beneficiary does not want. Still you want to impose the land on him.
KIDV is the beneficiary here, Lord, and.
No. No, that you are a only immediate beneficiary. The immediate beneficiary
Yes.
is the other person.
BCCI.
This is how Apex Court has said in one KIDB matter.
Yes.
We will, my lord, make our submissions. Your lordship may kindly.
And my lord, very strangely, my lord, before the, yes,
Fix a date.
please,
So the 11 notification is still surviving?
please, my lord.
BCC. Subsequently, because of this, BCC said we will not, we
That
don't
drop.
want it. Even then they want to proceed with the. and it is
You
in
want
the
to proceed with the 2011 notification?
My lord, it's not so, my lord. In fact, after the first writ petition was disposed of, my lord, writ appeal was filed. In 2015, my lord, writ appeal was disposed of. Immediately thereafter, my lord, one of the landowners, my lord, filed another writ petition challenging the notification. That matter was disposed of, my lord, along with these matters in 2023. And my lord, petitioner filed one more writ petition in 2022 seeking quashing of the, my lord, final notification. Matter was, my lord, pending before this honorable court. That is the reason for not issuing the final notification. We can satisfy your lordship, my lord, on that. But, my lord, there were continuous litigations in respect of this very notification, and the board has taken a decision to go ahead with, my lord, the acquisition.
BCCI is not requiring.
It does not, BCCI said, we do not want land. They say, no, BCCI should have this land.
My lords, the board has in fact taken into consideration all those things. There was demand for land from the industrialist. That is how, my lord, the board has, my lord, decided to go ahead with the acquisition.
What for
proceeding.
this land was notified?
That was notified, my lord, for the purpose of BCCI, and my lord, your lordship, my lord, may kindly appreciate this. If an acquisition, my lord, for a public purpose, my lord, a land acquired for a public purpose or notified for a public purpose can as well be used for any other public purpose. We'll satisfy, my lord, your lordships on that. I have, my lord, some submissions to make. Your lordship may kindly fix a date.
My lord, in page 252, their objections before the learned single judge was that we are requesting to drop the acquisition. In page 252 of the writ appeal, my lord. Paragraph 5.
That stage it was even dropped.
That's what.
For the case of. Today, June, in the second week of June.
Interim order is to be extended.
What is the interim?
My lord, may I request an earlier date, my lord? She is a senior citizen, my lord.
They have learned single.
Therefore,
use order.
when my lords was pleased to pass an interim order, my lords was pleased to observe the status of the, my lord, for 14 years, my lord, I can't sell the land, I can't do anything.
Therefore, June we are
My
disposing.
lord, little earlier, my lord, because I have a,
Here, the court vacation comes,
My lord-
summer comes, where you can also enjoy.
my lord, the
Wait,
thing is, even this land was converted land, my lord, KDB is not entitled. Any date earlier, my lord, if I just
30th May,
oblige.
Interim order.
interim order operating in the appeals 10, shall continue to operate till the next day.
Number 15, Mr. Sampath, yeah.
Complaint in my lord, for the accused in this matter, my lord, the
Complied with-
complied, my lord, the order has been complied, my lord. Can it be permitted? my lord, sir?
You are Karthikeyan,
Yes, my lord.
learned education V.S. Karthikeyan makes a statement. When the complaint comes up for consideration by producing memo dated 20th/3/24. Full stop. The memo paragraph, the memo reads as under. In the aforesaid view, after quoting. The directions are complied with, directions of learned single complied with. Learned advocate, Mr.
Yes,
So and so,
Sampath.
so and so. Sampath A is not in position to dispute the factum of compliance. Contempt proceedings are closed and disposed of.
Item 16, Mr. Rajshekar F.
Complainant. Order has been complied, my lords, I'm filing note that complied.
The same order.
Same.
What is RTC? Revenue?
Please.
Full.
Record of right, my lords.
RTC register.
Revenue tax.
Crop.
Same order.
Tenancy and crop.
Great.
December 17, Mr. Prasanna Kumar P.
Appearing for the appellant, my lords. As on the,
Delay is there.
as on the last date of hearing.
Delay is there.
No.
No.
Delay of 31 days.
31 days.
On the last date of hearing, my lords were pleased to dispense with the serving of copies. The councils have received copies. And the court had-
Only where the Wakalat only on behalf of R2, R3, R5 and 12 men.
The copies have been served, my lords, to the other councils on record before the learned single judge. In fact, on the last date of hearing, my lords were pleased to direct it to be listed on 28 by dispensing the office objection.
Office objection dispensed with.
Yeah, it was overruled. I'm appalled.
You have to take steps for unserved respondents, no?
I'll take fresh steps. my lords.
Learned advocate shall, for the appellant shall take necessary steps in respect of unserved respondents. Reopen first week after.
Great.
Number 18. Mr. R.B. Sadashivappa.
Your Lordship, the direction was to allot alternative land. Lordship, the draft sale deed is sent for approval. Even in 3 days' time also we will comply. For the registration of sale.
Complaints that. We can record the statement and dispose of.
No, Your Lordship, it may be kept open. It's all right until we, because he does not seem like.
Put on your mic.
It may be kept open until we will register sale deed. That's all right, Your Lordship.
They want 3 days time to comply with my lord, to execute the sale.
Only because of election duty, it could not be done.
When will be within a week?
When are you going to do?
Your Lordship may list it in the next week and we will.
Next Thursday.
Recording the submission in the event.
We'll
they do not do,
dispose.
that will be aggravated contempt.
If any.
Undertaking, we
if
will record.
Dispose of any difficulty.
My lord may have
And
it,
if they do not do, we have taken the view, it will be an aggravated contempt.
kindly have it, my lord, next week so that they comply with it, my lord, because I am interested in compliance than anything else.
Anyway, do it
Yes.
next Thursday. To be listed at 2:30.
Please, great.
Number 19.
Write down, since the order awaits the compliance, the statement of the counsel for the accused. Kumar, to be listed at 2:30 on next Thursday will be what, whichever date is it? 28th of March.
For the appellant, my lord, I filed an application
19.
to bring the legal representatives of the deceased respondent number 3 on record, my lord. There's a delay of 38 days in doing the same, my lord.
It's I was representing respondent number 3 minutes earlier, but I have been instructed to appear on behalf of legal representatives of respondent number 3, 8 and B. But I'll file my wakalat within 1 week, my lord.
So that application formally has to be allowed.
It can be allowed.
Death of respondent number
3, my lord.
Yes.
The application supported by an affidavit to bring the LRs of deceased respondent number 3 has been filed. First off. The learned counsel, Sri Vivekananda, undertakes to appear for the LRs, and he says that he has no objection for allowing this application. First off, in view of the above, the application having been favored, the LRs of the deceased shall be brought on the cost title immediately. First up, the registry to show name of Mr. Vivekananda as representing the said LRs. Please.
December 20,
My lord, there was an interim order that was operating that will kindly be.
Interim order to continue till next date of hearing.
number 20, Mr. Gopal Krishna Gowda.
For the
My lord,
complaint,
the order dated 5/2/2024 has been
out of
complied.
35 lakhs, my
And
lord,
out of,
only 5
and
lakh
apart
they have
from that,
deposited,
the
my
order
lord.
of the learner single judge has been challenged in the apex court, my lord.
Let's see what is it, what it is.
Direction to pay the maintenance.
Houdu.
Alimony.
Yes. Page number 31 is the order, my lord. The petitioner, defend number 1 and defend number 2 and 3 are granted time up to 15/7/2023 to comply with the direction issued by the trial court in the impugned order. My lord, the impugned order, the order of the court below, my lord.
Please, wait. You have to look at the judges also. Now, what is the amount payable as per the calculation?
Around 39 and odd, man.
39.5 lakh.
Yeah, yes, ma'am.
How much is paid now?
29 and half.
Another 10 is payable.
My lord, the order of the learned single judge has been challenged before the
Only
apex
yes paid
court.
only
I
5
produced
lakh.
the copy in the last date
Is
of
there
hearing.
any stay?
It is likely to be listed in the last week of February, April, my
First day.
lord. Likely to be listed.
Stay illa.
Taylor, but he has filed. Anyway, now he has paid 29 is
No,
paid.
only 5 lakh he has paid.
Only 5.
Yes, sir.
My lord, the 21 lakhs has been received by them before the trial court, and by virtue of the order passed by this honorable court, I was directed to pay 5 lakh rupees that has been complied,
That's a wrong
and it
submission,
has
my
been
lord.
deposited. And I've placed the memo before this honorable court, and it is recorded also, my lord.
As per memo dated 5/2/2024,
What further amount will be deposited?
Further amount to be deposited.
yes, ma'am.
Is there is no dispute about the madam being wife and the
There is,
child.
my lord, because there is a will executed by the deceased in favor of the accused. And it is a subject matter of the trial of the suit. Hence, the order of the learned single judge has been appealed before the honorable apex court. Only till then I may be permitted.
No, not till then. How much? Now you have paid only 5 lakh. Another, you pay another 5 lakh rupees so that we will call this matter after a few days.
My lord, he is a patient and he has no money. With respect to that, my lord, there was an order passed by this honorable court to pay minimum 5 lakhs to show my bona fide. I have complied with the order and have filed an appeal before the honorable apex court.
Similar. I used to direct the arrest and detention of the husbands for not making payment. That order. One. If he pays another 5 lakh, then we'll give that. Otherwise, we can do the direct arrest and detention, or we can give some time so that in the meanwhile he will do.
And-
Arrest and detention.
And my
is the
lord,
only
there
way.
is one more content petition pending before this honorable court in CCC 192 of 2024, my lord. Kindly, that
If
matter
you
is-
agree for payment of another 5 lakh, then we'll consider even. Otherwise, we are just discussing as to whether arrest and detention also can be done. That way we are thinking.
My lord, I have appealed before the
You have
honorable
said
apex
now.
court, my lord.
Anything new
What
argument?
is the total amount payable?
39 lakhs.
My lord, as per
39
as per the direction of the trial court, the death benefits and the LIC benefits has to be deposited before the trial court is around 29 lakhs. Which has been settled in my favor according to the will executed by the deceased, my lord. And
39
the-
lakh is payable.
Yes.
No, that is a total wrong submission, around 34 lakh and all. 29 lakh
Is paid.
amount received by the employer.
Out of 39, 5 lakhs is
5
paid.
lakhs.
Yes,
So
ma'am.
34 is payable. 35, 3 is paid, 34 is payable. So the
Approximately around
only
29.
consideration today is how much amount will be paying within next 10 days or 15 days. So we only two options.
Yes.
Either to answer or invite our order. And there is no way you can escape the
Madam,
obligation.
My lord, I'm not asking for any escapism, my lord. I have exercised my right before the apex court, my lord. And request
Well,
to,
let her sit with the child. Where the lady and that child should go? What they should do?
my lord, there is a will executed in
What
my
we should
favor.
do with the will? There is an order, already it is upheld and you are
It has
before the
been
apex
challenged, my
court.
lord. It has been challenged before the apex court.
Any
That makes
order
no
is
sense.
passed by the apex court.
No.
My lord,
Any order is passed by the apex court.
it's likely to be listed. my
Likely
lord,
to
that's
be
fine.
no, the answer in court of law.
Only 15 days time may be granted. I'll update about the developments along with the order sheet of the apex court, my lord.
For updation, we will not give. For making payment, we can give.
My lord, I'm not appearing over there, madam, because I have to seek instructions what has happened before the apex court, madam.
No, we are on payment. What amount will be paid? Since we are telling,
The another matter is
we are
directed.
telling you softly, but we'll be stern in our order. You decide right at now. We don't want to prolong the debate on this aspect.
Kindly matter may be passed over. Matter may be passed over.
Pass over. 2:30? Take instructions, yes.
This is number 21, the PM Siddhamalappa.
Yeah, file complaints of
Complainant. My lord, the order of the single judge was to consider the representation made by the complainant within a period of 3 months. In the compliance affidavit filed by the accused, my lord, they have simply referred the matter to the assistant commissioner, my lord, without considering the representation or passing any order on the representation.
No, we have considered the representation, cancelled the grant. For cancellation of grant, we have referred to the assistant commissioner. And they have suppressed all the material facts before the committee, grant committee.
It is considered.
Well, my lord,
wrong.
my lord, in an earlier round of litigation, the land grant committee had dismissed the representation, my lord, which was challenged before the AC and the DC and before this Honorable High Court, which in which they remitted the matter back to the land grant committee for fresh consideration of the matter, my lord, where they issued a Sagoli Cheety in our name. Even after issuance of the Sagoli Cheety, the name has not been, the revenue documents have not been changed.
But consideration has taken place. It may be wrong. How can we examine whether it is right or wrong? We have a limited jurisdiction in contempt cases.
No, my lord. Now the matter has been referred to the assistant commissioner, my lord. The fresh.
Some decision is taken or not? Taken or not? Some decision is taken or not?
No, my lord. No endorsement has been passed.
No, it is.
R3 is the endorsement.
It is placed on record.
Placed on record.
That is dated
21 to 23.
21 to, yes, 21. Here it is. Annexure R3. So once it is there, nothing survives in this process, madam. Is the decision last paragraph. Learned single judge by the order dated 22 November 22/11/22 passed in the writ petition directed the consideration of the petitioner supposed to be as representation within stipulated time. It was in relation to the petitioner's grievance about non-updation of the revenue records in terms of the grant order. This contempt petition was filed, came to be filed, complaining that the direction regarding representation has not been complied with. Post of the response filed by the accused, along with the compliance affidavit from response, decision dated 21 to 23 of the Tehsildar, Kunigal Taluk, is placed on record. The Tehsildar has taken a decision that in the effects of the case, the entries was not liable to be made Also, the decision is therefore taken. Paragraph, as the decision is taken, the directions of learner single judge are complied with. Nothing further survives in the contempt proceedings. The proceedings are closed. If the complainant is aggrieved by the decision, he is not precluded from instituting the independent proceedings to challenge the decision, in respect of which the court, however, does not express any opinion on merits. Disposed of accordingly.
Number 22. Shruti Bellayar. Reading.
Therefore, respondents are not in.
Hey, please. Clear for the appellants. The appellants are working as assistant professors, as guest faculty members, right from the year 2000.
The office has raised several objections, that my objection has been duly complied. I am for including it.
That no appointment shall be made.
Yes, university
Yes,
made this.
You have made.
No, no,
No,
I
I am-
appear for the appellant.
So that will satisfy you?
Sorry?
Will it satisfy you, that order arrangement, interim arrangement?
That no appointment shall be
No
made.
appointment shall be made pending disposal of the appeal. Appeal is admitted.
But every day they are appointing new faculty members. I placed the material.
Even after undertaking.
Yes, even
No, no.
after undertaking, and.
I don't think, my lord, there is any
The
appointment.
very statement
After-
made to the court resulting in the dismissal of my petition was per se false, suppressing the information. They had already invited applications. Just one document I'll show, page 193 may kindly be. Approved.
The undertaking is to the effect.
Yes.
No appointment shall be made, not that no application shall be invited. There is difference between these
I
two.
bow down to that observation. But
They
even.
may
be-
prepare everything, but short of appointment. That's the undertaking.
So they have appointed.
Have made appointment also?
Yes.
Lord, the petitioners were appointed initially for a period of 5 years on contract basis. The term is over. In spite of that, my lord, they have obtained the interim order. Then, my lord, because that they have obtained an interim order on the ground that there is a COVID-19 situation, there is a state government order to continue them.
Simple.
Yes, my lord.
You have given an undertaking to the court,
Yes,
which the court, headed by Honorable Chief Justice, acted upon.
Yes.
Question is, they are complaining you have made appointment. Have you made appointment or not?
Lord, my
That is
submission.
the question.
Yes.
If made,
Yes.
what are the justifiable circumstances?
That's true. This order, my lord, is dated 12th of February 2024.
Correct.
My lord, my instructions, my lord, after that, my lord, no appointment has been made until today.
After this order.
Yes.
We'll
If
record that
anything
they
is
made,
there,
then
my
it
lord,
will go
let them produce.
Kindly take my memo dated 15/3. I have placed the material.
Professor, for the apex court said, where in an appeal an undertaking is given and that is violated, the proper course is to adopt the prescribed procedure.
I respectfully agree. Now I am on the appeal. I want the order of the learned single judge to be set aside for the simple reason.
For hearing now, it's very difficult. Matter is admitted
No, I will.
after hearing you.
I will show that it was a false statement to the court. I will demonstrate. Two statements were made that there is no need for any faculty members.
Not only that, my lord.
And the, I think my learned
Yes,
friend
yes,
will
I'm
allow
sorry.
me to make. Kindly take the order at page 28. Sir,
Can we fix a date so that we can undertake expeditious disposal?
anytime this month I'll be. ready.
This month is very.
Sir, we are kept out of employment. We have crossed the age limit. We have worked right from 2016. Our prayer is very simple. These are all permanent posts, sanctioned posts. Notify and make regular recruitment. Till then, don't dispense with our services because it is now well settled that one temporary lecturer cannot be replaced by another.
You are in service today?
No.
Pursuant to the order of the learned single judge, we have waited. Till the order of the learned single judge, we were in service, right from 2000.
Today you are not in service. The entire complexion is different. If you are in service, then we could have viewed the thing differently to continue you till the.
I observe, I go down to that observation. We have been relieved after the order. And by the time we came to this court, we were already relieved. That also I placed before. But they are continuing to make appointments.
No, they have said we have not. For that appropriate procedure.
Any time this month I'll be great.
Reopen.
Sir, without employment.
Immediately after reopening, we will have this.
Immediately.
Sir, we have waited. Kindly look at the order sheet. How many times the matter come up? Every time the university asks for a short accommodation.
No,
and
not
it
the
goes off
university.
board.
Please.
There are old matters pending.
Every time.
We can't in that way give priority. Despite that, we are giving priority by keeping it on the first week of reopening. So when
Whichever date you choose.
29th May.
Much of.
29th May.
Sir, if I may say so with respect, this is a problem which is plaguing all the universities in the state. There is no regular faculty appointed. Vice chancellors are hiring and firing. That not even 30% of the students.
The quality of education which they have continued.
This was a very prestigious college, a college where the then President Mr. Radhakrishnan taught. Greatest vice chancellors. Coimbu was himself the principal of this college. That college is now reduced to a state where people are hired and fired at the whims and fancies of the vice chancellor.
This situation has arose because there is a bar from the state government to appoint any regular appointments. Everybody is retiring. Nobody is there, my lord. We cannot make a regular appointment. All this temporary, my lord, this not only in my lord, as rightly said, not only in this university, in all the universities, this is the position. That is the problem, my lord.
Sir,
There is a bar for
Umadevi is a
regular.
complete answer to this. Similarly dismissed professors who had not preferred the writ petition.
If
went
regular
before-
teachers are not appointed, there is one commission report which says if substandard people are appointed as teachers, they will produce substandard students. And the public interest would be affected.
That's one.
Sir, not only public interest, sir, I go down to this. A whole generation will
Generation gets spoiled.
Whole generation.
To kill a nation,
correct.
Mandela said, the best way to kill a nation is to downgrade the educational institutions. Education, that is therefore our scriptures say, Nahi jnanena sadrusham pavitrameha vidyate. The education. Therefore, education, agitate, organize. Baba Sahib used to say. Organize, agitate, and educate. 3 mantras.
Nahi jnanena sadrusham is the university logo. University. This is the university logo.
We'll fix a date. That day we'll take up the matter.
29th May.
Undertaking. March 29/5.
May 29th.
23 urgent, seal number 24 to Shekhar N.
My Lordship, PL Sanjeev undertakes to file wakalat for respondents, my Lordship. My Lordship, BL Sanjeev undertakes to file wakalat for respondents, my Lordship.
Correct, now you're filing now.
Hang back, my lord, notice has been served, my lord. Again, my lord, the council.
So we'll file you, we will give you time to file Vakalatnama and also to comply. Both time will coincide. Within 3 weeks, you file Vakalatnama and also comply with the direction.
Please, my
Pension and graduation.
Please, my Lordship.
Learned counsel, Miss, what's your name? What's your good name?
Pratima Vijay, my Lordship.
Pratima
Vijay.
Vish
Vijay, my Lordship.
Vijay.
Yes, my Lordship.
appears for the respondent accused and seeks time to file Vakalatnama. Full stop. The directions brought under contempt are with regard to the deciding of
Terminal benefits. Terminal benefits. Pension and.
presentation of the petitioner about payment of the
Elevated spirit.
pensionary and
Pension
gratuity
limit.
benefits. Full stop. While granting time to file Vakalatnama, it is observed and expected that the directions shall be complied with before the next date. Stand over to 4th of April.
Yes, my Lordship.
4th.
Number 25, Dilip M.
That's in serial number 25. There are 4 connected matters. I was a writ petitioner before the court. That's 25.2. The copy has not been served upon me. Now, insofar as 25.1 and 3, my lords, I just got a copy served upon me. My lords, to serve the copy, it may be taken up together. The short point is that, my lords, it was on a consent that, my lords, the writ petition order came to be passed, whereby, my lords, there were certain Benaami transactions which were alleged against the writ petitioners, that is me, my lords. After pursuant to the judgment by Ganpati Dealcom last year, all these petitions, my lords, were covered by virtue of that particular judgment. Now, my lords, they're coming before this court saying that 2 of the transactions are not covered, which, my lords, I have to answer. Before that, my lords, there's another preliminary issue where the judgment has been passed by way of a consent, my lords, that the entire subject matter is covered. Even the Union of India has made a statement to that effect. That's a writ appeal in that scenario may not arise or survive, my lords. Number 1. Number 2, there's a delay of 288 days.
Yes.
My lord, it's my revenues appeal, my lord, I may be permitted to.
Copy
submit,
serve
my lord.
ಮಾಡಬೇಕು.
You should notice and require you to serve copy.
Please.
Notice was already issued on me, my lords, but copy was served today too.
My lord, I am told, my lord, online, my lord, we have.
We can condone.
That's delay. It's 288 minutes. Look at the reasons given, my
My lord,
lords.
I'll.
Anyway.
They're hit by the. Because my lords, may see the reasoning given. They say that a review petition has been filed before the Supreme Court to review the judgment of the Supreme Court.
That can be agreed in some other matter. Judgment in some other matter. That Ganapati.
Yes, my lords. That ground.
My lord,
they're
the
alleging
short
saying-
issue was, my lord, whether the amendments made in 2016.
I had to.
But you were given a notice along with that, you should have come with the objection. Filing wakalat one date, objection
No,
to
that's-
IA another
May-
date. That is not the object. We are wasting time of the court that way. You should have come even in content matter. I want to file wakalat for the respondent. What is that?
Right.
Please read the rules.
I make
When you
myself-
are given time, you should have filed the objection. saying that preliminarily we are filing objection to the IA.
Copy-
Other objections to other things we will file later. That's not your stand.
That's the copy of the IA was not served on the last hearing. It was served upon me, and today, even today, petition number 25.2 is not being served upon me.
That all right. So far as two petitions are concerned, the
So
appeals are.
totally 4 methods, out of which only one was served upon me and IA was not served. In fact, that statement was made by me and they served the copy. I'm only seeking methods a short accommodation. That's I leave it to methods. Because these are two grounds which I'm stating methods to say that condonation may not be accepted methods.
So I can condone the delay.
Yes, yes, we should condone the objection. That's very good service. It's not that there was no delay, we would have disposed of the matter itself. All those matters are in the cupboard of the court for years.
Reasons were of that nature, methods which. Please, methods.
The writ appeal is proposed to be filed to challenge the judgment and order of learned single judge dated 19/9/22, whereby learned single judge has quashed the proceeding initiated against the respondent herein under the prohibition of Benaami Property Transaction Act 1988, holding that the transactions were not covered by the amendment made in the act. In preferring this writ appeal, delay of 288 days.
288 days.
280
methods,
days
that's
has
for the
taken
first
place.
petition. The other
Full
one-
stop. The present interim application is filed seeking condonation of the delay. The averments made in the supporting affidavit are examined by the court. Full stop. The reasons are bona fide. Element of indolence or negligence or the conduct of whiling away the time would not be attributed on the appellant. Sufficient force can be said to be made out to condone the delay. Delay is condoned. Interim application is allowed.
That's the delay, number of days for the subsequent petitions, methods are 384. That has to be changed.
Days to be counted.
It's mentioned in the causes. That days has to.
So now we'll post the appeal when
That's after.
Any
vacation.
date?
give copy to the
Please.
It's after.
after vacation. After vacation. Appeal may be listed
Sometime.
after vacation. In the meantime, copy of the appeal memo shall be supplied to the Honorable Mr. Chaudhary, Mahesh Chaudhary.
Great.
Notice it is 1 and 2 returnable on give first any date in the first week of June.
Chaudhary himself takes that. Chaudhary himself.
You are accepting the note?
Yes, he accepts.
You are accepting.
Panel
it.
counsel.
That I accept.
Formal notice.
Yes, ma'am, it's formal.
It's written on so and so and so. Be on 4 June, learned advocate Mr. Mahesh Chaudhary accepts the notice on behalf of respondent 1 and 2. Yes.
Number 26, Mr. Sampath Anand Shetty.
This matter we are compliant. I will be filing compliance affidavit within a week.
Within a week. Tuesday. Next Tuesday. Learned government counsel, Mr. Mahendra stated that the compliance, that the order is complied with and the compliance affidavit will be filed within 1 week. In that we post the present contempt application on 26th of March at 2:30.
Obliged.
Number 27, Mr. Pradeep Sarkar.
And in serial number 27, but if there is a connected writ appeal. My lord, in a connected writ appeal, your lordship have passed an order, my lord, to post it along with this. But say, your lordship may kindly see this order. It's a common
Translations
order
also
passed by the learned single judge. Date is also. Murder this, murder, I will file objections. I will.
Sorry, I'm passing it across the.
But as far as his application, half his objections are not complete.
That we have noted.
We will file the objections, my lord, whatever. Lord, my request is, my lord, let it be posted along with that. I will file objections, my lord.
But in the meanwhile, you
In the
should not.
meantime,
do.
you should not.
In the meanwhile,
this
we'll
is-
accede to your request. But in the meanwhile, you are not supposed to encumber the property.
Alienate.
You file objections. We will not pass final order on that.
But that permission itself is not granted, I think. No, my lord, they have not served copy, nothing. my lord. Permission is not itself, my lord, and in so fast, my lord, they cannot alienate us.
Therefore, we will not alienate the property. We'll record that permission. You say that permission is not granted for alienation. Therefore, question of alienating it will not
Allah,
arise.
permission, my lord, is pending, I think.
That's what.
Not yet granted.
That's what. That only will write.
While the court accepts the request of learned advocate, Mr.
Keshav Bhatt. A. Keshav Bhatt.
A. Keshav, on behalf of the respondent, to post the writ application on
Yes.
which date?
Along with.
My lord, writ appeal number, my lord, 223 of 24.
On 15th April, which is the date already fixed in the appeal.
But it is fixed to
So then how can we?
13th,
Call this matter along with this.
or 15th April.
15th April, along with the cognate writ appeal number 223 of 24, comma, having examined the impugned judgment and order of learned single judge with the help of learned senior advocate Mr. Ram Das, comma, the court finds that in order that the equities are not changed, comma, the respondent shall not deal with in any manner and shall not encumber in any manner the subject matter property till the next date.
Till the next date.
Yes.
That's right.
Let them serve a set of papers.
You already served.
You two sides.
Unless I serve, his name would not have been shown, except the paper which I passed on to your lordship this morning. All the other papers.
In office statement corrections, no.
All right, one more set.
One more.
He has not filed translation papers itself.
Yes, yes, that is objection, my lord. That is because, my lord, I don't want to expatiate on that, my lord.
Copy
We'll
and
comply
coffee
with the
both.
orders.
Copy and coffee both. Yes.
Number 28, Mr. Mahesh
Respondent
Kiran
pending.
Shetty.
my lord, office objections, my lord, some Kannada documents which we don't rely upon both sides, they will not be relevant. And some legitimate copies have also been furnished. So, since there is urgency, I pray your lordship to be pleased to hear this matter for the admission.
The delay of 6 days, sir.
Please.
Delay of 6 days.
My lord, my friend is
Sir,
there.
if he agrees.
Where is the date?
6 days delays.
6 days. So I have 1 of 24. Having considered the submissions of learned senior advocate Mr. Acharya, assisted by learned advocate so and so, and learned senior advocate Mr. Udayola, assisted by learned advocate so and so, and having gone through the developments in the supporting affidavit, sufficient cause is made out, condone the delay. Delay is condoned, IA is allowed. Now?
Please.
So delay is condoned. Now what is the subject matter?
Appeal is directed, my lord, against a order of the learned single judge by which he has allowed the writ petition, holding that my statutory right of appeal before the Karnataka Appellate Tribunal has been obliterated because of some orders passed by this honorable court, my lord, in execution of the award which was being executed. The Karnataka Appellate Tribunal held that it is a statutory appeal. Appeal is admitted and stay granted. Against that, my lord, they filed a writ petition challenging the order of the Karnataka Appellate Tribunal, my lord. I'll briefly state the facts, my lord, very few facts. My lord, the appellant and the second respondent, my lord, is a cooperative society. They entered into a development, land development and accumulation agreement, my lord. And in the course of the execution of the agreement between them, certain disputes arose, my lord. And the second respondent raised a dispute before the joint registrar under section 30, my lord, of the 70 of the Cooperative Societies Act, my lord. No, lord, I contended that the joint registrar has no right because section 70 doesn't apply, and I filed a writ petition. And during the pendency of the writ petition, my lord, the joint registrar went ahead with the inquiry and passed an award saying that I should pay a sum of 17 crores plus 3 crores damages to the second respondent, Lord. Now, since during the pendency of the writ petition, this was passed, the writ petition was amended, my lord. I also prayed for quashing of the award made by the joint registrar and also the execution filed immediately thereafter, all this. The learned single judge, my lord, disposed of that writ petition by an order, my lord, dated 28/8/2017. By that order, my lord, he held the joint registrar has jurisdiction in the matter. But the award passed by him is by ignoring principles of natural justice without giving me an opportunity to cross-examine and also lead my evidence. And therefore, he set aside the award passed by him, also set aside the execution pursuant to which has gone on for auction and all that. Now, that order, my lord, kindly see, my lord, it is at the page, my lord, 168. 77, my lord. It starts at 168, my lord, but the relevant portion at page 178, my lord. The learned judge says that the petitioner has to be provided an opportunity to lead evidence, participate in the proceeding. It is seen remedy of appeal available to petitioner would be effective to challenge the award passed on merits. Therefore, without expressing any opinion on merits of various contentions urged, the matter deserves to be sent back to the joint registrar to provide an opportunity herein to participate in the proceedings by cross-examining the witnesses and also leading his own evidence. Such recourse has to be adopted in this case as an exception to the general rule of relegating the party to a forum, because petitioner has to be given an opinion. However, such a remedy cannot be made use of by petitioner without putting him on terms. He is therefore directed to deposit ₹2 crores before the society, pay them 2 crores and produce the receipt. Now, my lord, the final order in para 14 is to that effect. If I don't deposit, you will not have the benefit of this order by which it is been remanded and all that. No, my lord, it was not possible for me, my lord, to deposit 2 crores within the 2 months' time.
If
He
that
granted-
money is not paid, what the order says, what would follow?
It's 29.
179.
Last 4 lines. Para 14.
179 last, my lord.
It is however made clear. Last 6 lines.
However made clear that
No, he says, taking jurisdiction he has got, but the award is set aside, execution is also set aside.
In other words, what is past is revived as phoenix.
No, my lord, kindly see, my lord, the subsequent events are very important, which has been ignored by the learned single judge.
Just we want to know, did you make the deposit as directed by the learned single judge?
Yes, yes, my lord, that's what I am saying. My lord, I filed IA-1 of 18, my lord, in this very writ petition after this order, praying for extension of time. That is important, my lord. Kindly note. Now, IA-1 of 18 was filed and that was pending before this honorable court.
IA-1 of 18 was filed on?
15/3. 18, my lord.
Seeking extension of period for making the payment.
By then, my lord, even execution has been proceeded, some properties were sold. In addition to that, my lord, the property belonging to my wife was also brought up for sale, alleging that it is the property of the husband and therefore it is also liable to be sold. Now, that auction notice, my lord, was challenged by my wife before this honorable court, my lord. Challenge to the execution filed before this auction, before this honorable court. That, my lord, came up for orders before this honorable court on 21/3.
That was challenged in
18.
WP. Was it challenged in WP? In separate WP?
Yes, a separate writ petition by my wife challenging
WP number?
12294 by 2000.
122/94 of 18, my lord. No, my lord, that is important. Kindly, my lord, It is in the second volume, I am sorry, page 531, my lord. 531.
We'll look into that. Before that, can you please tell us, Mr. Acharya,
Yes.
what happened to your application for extension of the
No,
period?
1 minute, my lord. I am coming sequence wise, my lord, because it will be easier. I will not take much time, my lord. Page is 531, my lord. My lord, at page 519, your lordship gets this order commencement, page 519, my lord.
529.
I'm sorry, 529, my lord. I'm sorry. Matter came up before her lordship. The two writ petitions
Yes.
by my wife. No, my lord.
Why two writ petitions?
There were two auctions.
Two auctions.
Yeah. No. It refers to the award passed against me and the wife's property being the relevant portion, page 531, my lord. Kindly see, my lord. No, para 2, my lord. The aforesaid submission is vehemently opposed by learned counsel appearing for the second respondent containing petitioner and third respondent. Third respondent, my lord, is myself, husband. Oh, that is the judgment at our here. So she filed the writ.
Wife
saying
was
it
the
is-
petitioner
It is
and,
my property.
Her husband was one of the respondents.
Yes, he is the third respondent. Their case is, though it stands in the name of the wife, it is actually husband's. That's why. See. So, and before authorities and not being successful in any forum are only procrastinating the enforcement. He reiterates that the direction given by the learned single judge on 28/8/2017, that is the one, my lord, directing me to deposit
14.
2 crores.
Para 14.
Have not been complied with by third respondent, and therefore second respondent society is justified in enforcing the award in his favor. At this stage, learned counsel for respondent, third respondent submits. Third respondent will deposit rupees 1.75 with second respondent society through RTGS during the course of the day, and the balance 25 lakhs shall be deposited with society on or before 26/3, that is 5 days later, my lord. In view of the aforesaid interim arrangement, annexure G1 and G2 are state. Then next, very important according to me, petitioner to ensure that the third respondent complies with the above direction. So direction is to comply with the order of 28/8 by depositing full 2 crores now. And admittedly, this has been done by 26, balance 25 lakhs was also paid. And in a, that is not disputed. The society has taken into account these 2 crores as having been deposited pursuant to order in the main writ petition. And kindly see, my lord, this is done.
Paid by the appellant herein.
Yes, appellant.
Appellant herein.
Yes. So this is kindly note, my lord.
Subsequent orders are there. 4 of them went to the Supreme Court also.
This was, my lord, when my IA1 of 18 is pending, praying for extension of time to deposit. And in this, no, my lord, the learned single judge and other earlier rulings, they proceed on the footing what I have done is in this writ petition, it has nothing to do with the compliance with the order. Really, it is in compliance with this order. Then last also, my lord, that is to ensure that it is done. Now the learned single judge says it is a voluntary deposit. It has nothing to do with the award. The award can still be executed. I'll come to it later. So next step, as your lordship was pleased to say, IA1 of 18, my lord, ultimately came up for orders, my lord, before the learned single judge. And the order passed in that lord is the learned single judge in the present order itself, he has extracted, my lord, the order that is passed.
Page number. Before that, can you tell us what was the amount payable in terms of the challenged award made by the JRCS?
That is about 17
20
crores.
lakhs with interest. Today, 24 lakhs. Today it is 38 crores, my lord, which is 28 crores. 38 crores is the amount, you know.
Award was for?
Award was for 20 crores with interest. 20 crores. So, my lord, all that comes to now today, my lord, it's about 38 crores.
Order on IA for extension.
My lord, at page 27, my lord, in the first volume, page at page 26, bottom, my lord, the learned judge notes.
It's
Point
reproduced.
number 1.
It is reproduced in this order.
Yes, yes. The learned judge notes that order passed on 28/7 to deposit 2 crores. Para 3, my lord. Narendra order. No, my lord, it is forthcoming from records. Respondent number 1 did not deposit 2 crores as per order dated so and so and so and so. In view of the same, properties were attached pursuant to award and sale properties in public auction are held on so and so. Then respondent number 1 filed IA1 of 18 in WP so and so for extension of time to deposit a sum of rupees 2 crores, my lord. Now, this application, my lord, ultimately came up for orders before the learned judge on 13/11/2018, my lord. Now, your lordship, kindly note, long before this, my lord, on 26/3/18 itself, the entire payment has been made as undertaken before the learned judge in the writ petition filed by Y1. That is therefore, in effect, my lord, 2 crores have been deposited on 26/3, by 26/3. 1 crore 75 on 21 itself, and 5 days later, 26th. So by March, the entire amount has been deposited. Thereafter, this IA came up for orders. There was some mediation and all. Ultimate order is this, my lord. This court today order dated 13/11/18 passed on IA1 of 18 passed the following order. After hearing and perusing the pleadings, certain facts stand crystallized. It is apparent that the parties have been carrying on transaction which is in fact led to present imbroglio, and many a transaction is based on mutual trust. On account of certain facts beyond the control, parties have resorted to litigation, which this court is of opinion could be resolved by mediation arbitration. learned counsel for both parties submit that parties are willing to resolve the issue by way of arbitration, and that the dispute which has arisen can be adjudicated by arbitrator mutually agreeable to parties. And the learned counsel, senior counsel and learned counsel for petitioner have suggested name of Sri G. Patris Basavangowda, retired judge of the court. In this regard, Sri Justice so-and-so is appointed as arbitrator. Now, this order, my lord, is extracted, but I have produced, my lord, the order itself at page.
No, may not be necessary because it has been fully extracted. They do not dispute about this order.
Yes, no, but one thing, your lord, may kindly see the original order itself, my lord, at page 181. Page 181, my lord. Kindly see at the top, my lord, case number 26288 of 17. This is the original same writ petition. And my lord, the order which I read, my lord, is in the next page. Next page, my lord. At the top, order on IA 1 in 2018, that is important. That is not extracted. And at the end, kindly see, my lord, parties are at liberty to communicate this order to Justice Pasri. Accordingly, IA 1 of 18 is disposed of.
This arbitration is the one which was pending before the JRCS. Which arbitration it is?
This is different arbitration, which my lord, the learned single judge, my lord, said, both of you can go to arbitration, both in wife's petition and husband's petition. What they do is, wife does not come. She does not enter appearance. Husband, my lord, enters appearance. We file a claim statement. Thereafter, my lord, what they do is.
We want to know which is the dispute that was that was to be arbitrated.
Entire dispute, my lord, which has been adjudicated by the
JRCS,
the joint registrar, those disputes are referred to arbitration. Because when the order is complied with, supposing IA, this is order on IA 1 of 18, instead of the matter going back to the
JRCS,
because of my deposit in complying with, though a few months later, according to me, my lord, the order of the learned single judge, he has set aside the award of the joint registrar and remanded the matter back to give opportunity. Instead of that, here the parties agree, let all the differences between them be settled by arbitrator. So the matter went to, and this is a consent order to which, my lord, the court also agreed that it is better that all the disputes are settled through arbitration. And, my lord, before the arbitrator, my lord, both sides filed their claim petitions regarding these very dispute, my lord, which has been adjudicated by the joint registrar.
Statutory arbitration. Subject to the condition. Or making the yes.
It will be divisible as me.
Since they created that this money was not, they thought that award of the JRCS that was crashed very well. They put it in enforcement and execution. They executed. It sold two properties belonging to the wife of the appellant. Two petitions. In both the petitions, the interim order was made to make payment of 1.75 plus 25. March 2018, they have made that. In application, 2018 was taken for extension. Both will say dispute can be resolved by arbitration. The dispute that was pending before GRCS.
Few more developments, my lord, which have led to the present.
Subsequently interpreted
Before-
by this court, confirmed by the division bench, confirmed by the Supreme Court. Sorry, my apologies. Sorry.
By doing any mistake, you can correct me, but
My apologies.
you see,
No.
I have suffered so much because of this.
Your
My
client,
lord,
we'll see, but
yes,
who has suffered will
my-
point out.
my-
You're all laborers.
My client is a very unfortunate person. I will just point out now. Now, before the arbitrators, my lord, both us as agreed, filed our claim statements regarding this very dispute, my lord, which is the subject matter.
Was there no other dispute that could be
No,
referred
no,
for
no,
arbitration?
No.
This-
If
That
at
was the
all,
same
if-
dispute.
If at all, the other dispute could be in execution, because three properties are already sold on the very day of 15/3, and also the dispute whether the property of my wife could be attached or not, my lord. That's why she is also made a party. So both sides have filed their claim statements, which will show in which, my lord, it is also considered that by 26/3, I have deposited 2 crores, and the claim for the balance with the interest is made, my lord. Then what happened was, the property has been sold and auctioned, and registered, and it's been executed in favor of purchasers. So before the arbitrator also felt that those purchasers would also be necessary parties. So impleading application is filed so that it may be adjudicated. Proceeding. The result was the London arbitrator has passed a detailed order
Deeds have been registered. How
No,
is
no,
that?
No. Appellant's property was sold. Three
Appellant's
items.
property was sold.
Yes, because they were sold earlier. Thereafter, my wife's property also they came, that was stayed. But these sales have taken place because all were done in such a great hurry, my lord. Immediately after 2 months' time is over.
So they will be parties.
Execution was already pending. So immediately they sold and executed registered sale deeds in June 2018. Before this arbitration order.
Therefore, the buyers claim the character under the appellant.
Yes, yes. Therefore, they would have been necessary parties. But now kindly see the order of the arbitrator, my lord, at page 183.
183, it is at 220. It begins at 183.
My lord, it's in the order at page 227, my lord.
Filed under section 30.
227.
Correct.
He says, consequently, it has to be concluded. Continuation of the present arbitral proceeding has become impossible. It is open to the parties that it should settle according to as advised. Arbitration proceeding is therefore hereby terminated under section 32(2)(c) of the Act.
Correct. Then what, further what happened?
So, then, my lord,
What happened to two writ petitions filed by the wife of appellant?
no, in that, my lord, on the very day, that is on 13/11, this arbitration order is passed, 13/11 itself, order on IA 1 of 18, the same order will bind
Put an end
in this
to-
also, and this is disposed of. Same day it was disposed of to that effect.
in terms of that order.
In
Both the
terms of
petitions.
order referring the dispute, to which my lord, wife is also a party. It was disposed of that day. Then, my lord, one fact which I forgot to mention
One
was,
small, this one, whether the buyers of the property in execution, were they parties to the writ petitions?
to the writ petitions, no, man.
They were not.
No, because the original writ petition, my lord, there was no sale held. In the writ petition, the challenge is originally the first notice by the joint registrar, challenging that he has no jurisdiction. Then during the course of the proceeding, award is passed. Execution is also filed. Both were under challenge in the writ. So the learned single judge set aside the award, set aside the execution.
No, that was, that we have seen that. In
that execution, subsequently, after 3 months period was over, the auction was held. 3 properties are sold. And there also another property was also sold.
No, whether buyers were not parties to the writ petitions filed by the spouse of the appellant.
No.
But
They were
auction
not
was,
concerned with that. My wife's writ petition was regarding her property.
That's what?
Which, yes, regarding that alone, challenge. Earlier, my own property in my name was already sold and the purchasers were there. And then, my lord, we filed a writ petition subsequently after this.
Today land is with you.
We filed a writ petition.
The buyers, that particular land property that were sold, 3 properties were sold pursuant to execution. What happened to those sales? I have already.
No, my lord.
Yes.
In view of this, my lord, we challenged this order of the arbitrator terminating the proceeding before civil court, my lord. That is pending. That is also opposed. We prayed that let any other arbitrator be appointed. Let there be,
This amounts to award.
which one?
This order dated 32/2C
No, it doesn't,
Award.
it doesn't amount to an award.
award. But otherwise challengeable under
Yeah,
35
under
something.
the specific provision, under order under 32 can be challenged. In the meantime, Lord, we filed a writ petition to cancel these sale deeds. And also, we should not have done it, Lord. We also said in view of the fact that the whole thing has become infructuous, also to refund 2 crores, which we have deposited in compliance. No,
What happened to the writ
no,
petition?
that's writ petition, yes. In fact, it is some observations in that writ petition and writ appeal, my lord, is made use of to say that I have lost my right of even filing an appeal. The writ petition was mainly dismissed on the ground, registered sale deeds can't be set aside in a writ jurisdiction, correct, my lord? And there is also no question of refunding 2 crores. They said it is voluntarily deposited by me. But they said it was not deposited in compliance with the order in the writ petition. That is
That,
totally wrong.
That order.
Deposit, that is at page 228, my lord.
Para 15.
My lord.
Yes.
Page 233, my lord.
This was the award possible for CS.
Please, my lord. No,
Award of 28th of April 17. Original award.
pardon?
28
28
April
April.
2017 order. That order was set aside in the writ petition.
Yes, yes.
And it went to the Supreme Court also.
That order and also execution were set aside.
Matter went to apex court. Which order went to apex
No,
court?
it is
Not
against this order, my lord. I'll refer.
It came before the
The
division bench.
apex court, I'll come. It is against this order, the present order I am now referring to.
Here.
That went up in appeal and SLP. I'll refer. No, my lord.
The Honorable
I
Justice.
won't
Dinesh Kumar.
take much
Dinesh
time.
Kumar's order went.
With this, we will,
Not that order. Subsequently. the petition of setting aside the functioning of the properties. There the court said the award had been, it could have been set at not only in appeal or appropriate proceeding. That is not happened. Therefore, it is called the petitioner in my child. And writ appeal also dismissed against that.
This is Aradhya's order, my lords get that at page 241, then review dismiss. Then went to the Supreme
Lord.
Court, 241 and 2.
my lord, I'll just take sequence or few minutes,
Very well.
I conclude. Page 233, the learned judge notes in this. The learned arbitrator held auction purchases are necessary parties for complete adjudication and to decide questions involved. Since proposed respondents have not agreed to be included, he terminated the proceedings under so and so. Then the point for consideration at page 236, my lord, in conspectus of the facts of the case, the point that arises for consideration is whether the statutory order passed by the joint registrar of companies stood obliviated simultaneously with the matter being referred to arbitration. And at page 237, the learned judge notes that IA for extension of time was filed. Then para 15, my lord, an order passed by the joint registrar under 70 is a statutory order and its effect can be nullified or set aside in a matter known to law. It could be either an appeal or a statute or judicial review 226 of the Constitution or in writ proceedings. In this case, it has been set aside in a writ proceeding by the learned single judge, subject to a condition which has been complied with, read with order on IA1 for extension of time within
That
5 months.
that appears to be factually true, but law comes in your way. What you have said is, factually it may be true, but there is a finding which runs counter to this argument. The finding is recorded, rightly or wrongly, affirmed in writ appeal.
That's why I respectfully submit, my lord, my argument is twofold. One is the order of the learned single judge in the writ petition directing deposit of 2 crores is substituted in that very writ petition by the subsequent order dated 1311. Please see, in that very writ petition. And that is the final order on IA1 of 18. Not anything independent. The judges here proceed on an erroneous impression that 2 crore deposit has something to do with my wife's writ petition. It is not so. There on their objection that I have not complied with this order, I agree to comply with it, not my wife. Third respondent agrees to comply with the order and I have complied with.
That's correct. But
thereafter, noticing that 1311 order is passed. Now, supposing the arbitrator, my lord, had given an award that I am liable to pay or I am entitled to anything, could it still have been said that they are entitled to proceed under the old award? Because this has the effect of modifying the earlier order in the very writ petition, which IA1. That is one thing now. But more important point in this case is, assuming we say the order award was right and even execution was proper, sale deed is proper, everything, assuming everything. If the award is there and in execution, whatever order has been passed, my lord, now the question is, when I have no other remedy, the court said arbitrator, that is not possible. Then don't I have the right, my lord, statutory right of challenging the award without any opportunity of pleading evidence or anything, no remand. The order of the joint registrar, which has been set aside by the single judge, if that is revived because of my failure to deposit within 2 months, will it take away my right to statutory appeal? And that's what the KPSC said. When I have no other remedy,
right of
in
appeal
fact, my lord,
arises.
against this order, which is affirmed in appeal, SLP is filed. At the SLP, the Supreme Court specifically, it did not say so in the order. After hearing for some time, I withdrew because they said, why should we exercise power under 136 when you have a statutory remedy of an appeal? So immediately after the Supreme Court, I withdrew the SRP, filed the appeal, and the KAT has passed the present order. My lord, after all, my lord, there should be some proportion between the lapse and the punishment, my lord. Now, I am not able to deposit within 2 months, but within 5 months from the due date, it has been done with the approval of the court in the wife's restriction, as also I gave one in this restriction itself. In fact, strictly, my lord, if we go by fact, the order of the learned single judge. In fact, strictly speaking, I am entitled to have the matter remanded because I have complied with the direction to deposit, and which is accepted by the court. If the court had merely said time extended till March, by which time I have deposited, but instead of that, it passed an order IA1, why remand, go back to the registrar and all that. Instead of let there be an arbitrator. I want to go in one remedy, my lord, against an order of the arbitrator, which according to the finding of the judge himself, is in violation of the principles of natural justice. That is why he said, you give opportunity to cross-examine, lead evidence, and do all that. Now, such an order, my lord, when the court felt arbitration is better, and both of us agreed. Kindly see, my lord, just page 238, the learned judge after.
Paragraph 15.
Kindly similar, page 238, he says, it could be either in appeal or provided in the statute or judicial review under 226 or it. There is no other proceeding other than the writ petition 26288 in which the order passed by the JRC is challenged. Due to petitioner's default, order passed by the joint registrar has remained undisturbed.
Undisturbed,
This is
and
not
therefore
correct,
it is
my lord.
executable. That's
It
how
is
said.
not.
It may be wrong. Mr.
true,
Acharya,
my
we
lord.
understand.
No,
This may be wrong.
I
But
appreciate
wrong
the-
also rejudicates you.
Lord, I agree, my lord, because we can't go against the law. But finality is one thing. My lord, in Antole's case, Justice MNVJ has quoted
Dissenting judgment.
Atkins, he
Not
said,
Atkins judgment.
finality is a good thing, but justice is better. And also, one judgment in 93, my lord, Justice Bhagavati has said that to perpetuate a mistake is no heroism. To rectify it is compulsion of judicial conscience.
How that principle?
Even if it is a erroneous order, my lord, can it be stretched to say, maximum you may say, order remain undisturbed,
No.
which is
Apex
wrong.
Court, no, Apex
But-
Court did not agree. Please take 1992 Supreme Court page 3111. Apex Court, after seeing Wade and Forsyth administrative law, said an order may be wrong order.
True, true.
It may be without jurisdiction, but it does not have on its forehead a brand of invalidity. Therefore, an order which is otherwise invalid in law, non-est in law, they have used the word non-est, unless challenged by the right person in right proceedings before the right forum and within the right time.
Please.
And or even nullity order
I bow
remains
down,
valid.
I bow down, my lord. I realize that position, whether right or wrong, when an order has been suffered, it will be binding between the parties. No, my lord,
Until settled.
my lord,
That's how it is
kindly,
said.
kindly see, my lord. Please, my lord, may I- 2 minutes, may I point. Page 239, my lord. 239.
311.
The para 17 regarding refund. Of course, I don't say it is wrong. I should not have claimed. Firstly, because first petitioner has paid the amount voluntarily as recorded by this court in his order dated so and so and connected matters filed by petitioner's wife challenging the proposed auction to sell her property. Secondly, no direction can be issued against a private party. Then, madam, most important, page 240, madam, 240. Be that as it may, the fact remains that the first petitioner has paid the amount of 2 crores in proceedings initiated by his wife challenging the proposed action of the property belonging to her, not in that. In that, the court said, you have not complied with that, do it. So saying that this 2 crores is deposited in this is not correct. And not compliance with the conditional order passed in the, then it is clear that the order dated 17 December, final order dated 28th April, passed by the joint registrar, remained intact, undisturbed. No, my lord, on facts, it is clearly erroneous because of a wrong understanding of the subsequent developments. In fact, true.
No, this may be factually incorrect. But unless you take some.
No, all this is, all this is to justify, my lord, their execution and subsequent matters. No, my lord, supposing there is a decree, my lord. Now it is put in execution. In the course of the execution, there may be so many orders, any order passed.
What you say is your right of appeal. Right of appeal remains intact, is your version.
That's what I am submitting, my lord. All that may happen, but with all this, can you say your right to file an appeal against the order, if it is revived and it is in force, is taken away?
No, that it is your right of appeal arises because of revival of the award.
Please.
Where
Therefore,
the
my
learned
lord,
single judge has said no right of appeal.
That is exactly what the appellate tribunal has held, my lord.
Where is that?
That is the order that was challenged before the single judge. And the single judge simply relying on these observations says, yes.
Substratum of all the proceedings. The GRC. Who was quashed? It was conditional on his making the payment. Must get the payment, let's assume it. Therefore, JRCS award divided. We'll assume that way. If award is executed, tribunal dismissed your appeal on the ground that the award was not appealable. No.
No.
It was appealable.
The the tribunal, my lord, entertained my appeal.
That is set
And-
aside by the,
And no,
Huh.
it granted stay.
correct,
At that stage, my lord, at the initial stage itself, the
WP was.
respondent filed a writ petition here challenging the order of the KAT entertaining the appeal. They filed an application to vacate the stay and also an IA to say that the appeal is not maintainable, but without, my lord, my lord, yes,
One second.
please,
Yes,
please.
Section
Yes.
70
Please,
award.
please.
Rises under section 10.
105. It is a statutory appeal.
Stays. It could not have been. Because right of appeal arises. So it is so held actually. Mr. Valla, the right of appeal arises.
No, my lord. Can I request your lordship?
We
just-
will put the proposition
yes,
to you
sorry,
so that
my
you may
apologies.
consider
Yes,
that
yes,
for a moment.
yes.
The right of appeal being a creature of law, it takes birth when the award is passed.
Correct.
Whether the award revived as phoenix or not, perhaps argument will be in your favor. Arguably, the answer is that award revived because, assuming, because the amount which he had paid on 21/3/2018 and 26/3/2018 in all 2 crore rupees pursuant to Honorable Justice Nagaratna's judgment, interim order, is not relatable to the order made in the writ petition, which had quashed the award, subject to the condition that if you make payment to the society, then the proceedings will be held afresh. This is what emerges from that award. And your argument, he has not paid.
No, not only that, sorry.
Further,
Yes,
I'll go.
Yes,
Just going
Yes,
by
my
the-
lord.
to
Please,
put the
please.
things in focus.
Yes.
Yes. Your contention was that the award revived. The amount paid under 2 writ petitions filed by appellant's spouse and the amount paid thereunder is not relatable to the amount payable under the order of the learned single judge who had quashed the award. We will assume it that way now. Therefore, the JRCS award revived, put into execution. 3 properties, 1 belonging to the appellant, 2 belonging to his spouse were disposed of.
No.
In
all-
execution.
All his own.
All right, execution took place, 1 rupee was paid. Now the question is, because an award is executed, does it kill the right of appeal? Is the question.
Correct.
And
Can I-
courts have
can I-
held,
Can
it
I
does not.
answer that, my lord? Please come to my lord, page 237, paragraph 15. And where is this thing? In fact, before the learned, my lord, when the writ petition was filed, when it was brought to the notice of the court that, my lord, appeal is, the JRC's order, my lord, is appealable. He said, no, I have a right, my lord, to come either under Article 226 or, my lord, an appeal. Please come to, my lord, para 15.
Yes.
An order, page 237, an
Yes.
order passed by the JRCS under section 70 is a statutory order, and its effect can be nullified only if it is set aside in the manner known to law.
Correct.
It could be either in appeal provided under the statute or in a judicial review under 226. He took recourse to judicial review, therefore, my lord, he did not opt for the appeal. And this honorable court, my lord, specifically held, please come to, my lord, page 240.
No, first 2 sentences I have not understood.
Sorry.
At least I have not understood.
My apologies, my apologies.
Section, the observations are, an award, it's not an order, it's an award.
Yes, my lord.
An award can be set aside by recourse to law.
Yes.
Not otherwise. Is the substance of inner meaning of this
No, my lord.
observation.
Either by filing an appeal, or my lord, by filing a writ petition.
Writ petition.
He took recourse as writ petition, not my lord the appeal. Therefore, my lord, his appeal, my lord, got obliterated, his
No.
right of appeal.
No, sir. In his writ petition, the award came to be set aside.
No, my lord. Can I?
That revived.
Can I persuade your lordships to just permit me to put it in the right perspective? Please come to my lord, the order at page 168. Let me put it in the right perspective, my lord, sequentially.
Appeal was paid.
What happened to appeal?
Appeal came to be quashed because the learned single judge has passed the order. How appeal could have been? Because you were very case, award has revived and it is put in execution. It was executable. These are the observations. If award is executed, right of appeal will not die. Any number of judgments on law of execution by Wilson, etc. Yes, sir.
In fact, I can tell your lordships, what the KAT has done is virtually sitting an appeal over your lordship's order, division bench's order, Supreme Court's order. Please come to my lord, page 179.
179.
The first order. In fact, there's a clear case of contempt. And I'll point out how. Please come to my lord, para 14, last 6 lines, 7 lines. It is however made clear that if the petitioner fails to deposit a sum of rupees 2 crores before the respondent society within 2 months from the today, fails to produce the receipt before the joint registrar for having deposited such amount, petitioner will not be entitled to the benefit of this order. On such default by the petitioner, respondent society would be entitled to proceed with the execution proceeding, implement the award passed by respondent number 1 on 28/4. Then what happened was, his wife also filed a writ petition.
Because her property is
Correct.
sold.
There, my lord, 2 crores he had to pay. What he says is, I will pay that 2 crores there in respect of Justice Nagaratna's order. This 2 crores is separate. He did not pay this. Then, my lord, the award, what happened was, now please come to my lord, running page 238. In the background of this.
No, we want to understand the effect of this order.
Yes.
In your words.
Yes, my lord. In this case, the award, my lord, got confirmed by your lordship's order. By my lord holding that, my lord, the award has become final. Because he took recourse to my lord writ petition, not my lord the appeal.
It was against the award.
Yes.
Award was quashed.
Correct.
Was it
Award,
quashed?
no, my lord. Award was set aside subject to my lord the condition that if you do not pay,
that's what.
Then my lord, it gets confirmed.
It was set aside.
Yes, my lord.
It was set aside. The requirement of making payment is in English law called condition subsequent.
Correct.
That condition subsequent having not been complied with, the award revived. Award was set aside. Award revived. That award is put in execution. If that award revives, will not right of appeal accrue?
Lord, in the background of what your lordship felt, please come to my lord the judgment of his lordship Justice Dinesh Kumar at page 228 and 237. Let's go, my lord, step by step, and I'll point out, my lord, division bench order also. Paragraph 15.
At page number
237.
Yes.
An order passed by the JRCS under section 70 of the Act is statutory order. Its effect can be nullified only if it is set aside in the manner known to law. It could be either in an appeal provided, in a statute, or in a judicial review under Article 226 of the Constitution in writ proceedings. Correct. There is no other proceedings other than the writ petition number so and so in which orders passed by the JRCS were challenged. Due to the first petitioner's default, order passed by the GRCS has remained undisturbed. Therefore, argument advanced on behalf of the petitioner that there is no executable order of the petitioner against the petitioner has no substance. Here, he took recourse to my lord the writ, not my lord the appeal. He chose my lord the remedy. If 2 remedies are available, if he chooses one, he can't say, I will take recourse to the other remedy, my lord, if I fail here. He, my lord, please look at this, my lord. Look at it, my lord, from this angle. I have the remedy either to go under Order 39, Rule 2A, my lord, for contempt, or, my lord, come before your lordships under the Contempt of Courts Act. If, my lord, I come before your lordships under the Contempt of Courts Act, and your lordships say there is no contempt, can he still go, my lord, under Order 39, Rule 2A and say, my CPC provides for it? This is, my lord, the thing. Then, my lord, please come to running page, my lord, 240. This honorable court held that, my lord, the award has become final.
240.
240. Be that as it may, fact that remains is that the first petitioner has paid the amount of 2 crores in the proceedings initiated by his wife, challenging the proposed auction of the property belonging to her and not in compliance with the conditional order passed in the writ petition file. This was challenged. In view of the above, Lord, please look at it. In view of the above discussion, it is clear that the order dated so-and-so and the final order dated so-and-so passed by the JRCS have remained intact, undisturbed, because this means your lordships have confirmed the order.
Correct.
He, my lord, had the option, as I said, either to file an appeal or a writ petition, as my lord was specifically held in page 238. Either, my lord, he can file an appeal under 105, or, my lord, come before your lords under Article 226. He, my lord, chose 226. Thereafter, he can't say, now I'll go back to 105, because what will happen is,
Let us have a next Thursday.
please, my lord.
Next Thursday.
We'll think and.
My thoughts are not crystallized.
No, my lord, that's why I gave you a lordship. My lord, I'll give some judgments also. I have the judgments. I'll give you a lordship.
Lord, I would like to submit, my lord, according to him, the award of the joint registrar is in force. And even now, apart from the property already.
It is
Are you saying
confirmed.
that?
No,
My lord,
my lord,
according to me, it is confirmed by your lordship.
my lord,
If it is confirmed by your lordship, they can't, my lord,
My lord,
again re-agitate it in an appeal
my
before
lord,
the district forum.
if-
My lord, appellate authority comprised of district
In-
judges. Your
in-
lordships have said, this award, I confirm it because
No.
you have challenged it. Your challenge is rejected. I confirm the award. If, my lord, he had two courses, appeal or, my lord, under Article 226. Your lordship, I'm supported by several authorities. I'll give you a lordship. May I have it, my lord, to next
my lord,
Thursday, we'll do
my
that.
lord, the question that not only so many properties are sold and registered, now they are going on. Now, in some properties were brought to sale. This honorable court was pleased to set aside on some technical ground and remanded the matter. And now the property is put up for sale, my lord, on 23rd.
Please
That's
come to, my
why
lord,
I
page
moved your
296.
lordship. It is, according to them, if the order of the joint registrar is in force even today, I respectfully submit, nobody has confirmed the award.
Please come to, my lord, page
The
296.
right of appeal cannot
auction
be
is-
so easily taken away.
Auction is scheduled on 23rd.
I
Auction is
must
over.
have some remedy.
Over.
Auction is over.
No,
My lord, please come to, my
No,
lord,
no,
page
no, my
296.
lord. No, my friend is not correct.
Please come to page 296. This Honorable Justice, my lord, Varale, my lord, as a sitting as Chief Justice of this court, specifically held, he directed, my lord, conduct a fresh auction. Then, my lord, they go before the KAT. It's a clear case of contempt. Please come to page 299. We direct the fourth respondent, assistant registrar, recovery officer to conduct. Page, my lord, it starts at page 296.
Whether auction took place?
Yes, yes.
When auction took place?
Today, my lord.
Today.
11 o'clock it was slated. That's why, my lord, they do not move your lordships, my lord, court for a long time, 36 days.
Not today.
18-1 was the
23rd.
judgment. 18-1 was the judgment.
18-1 was the judgment. Please look at it, my lord. 18-1 was the judgment.
Is there any confirmation period as it happens in auctioning of the property in execution of the
Yes,
decree?
yes.
What is the period for confirmation?
30 days, I think.
45 days. 45.
In fact, what happened was, yes, yes.
There
Thursday
we
was-
can, in the meantime,
Very good. Please,
here we go.
wait for me.
No confirmation takes place. The meanwhile, we'll.
Yes, please.
Paragraph 9 at page 299A.
Yes.
We make it clear that the respondent number 1 has not raised any grievance for the.
Post of caution. That's also, I just wanted to further, my lord, there are further other observations also. I'll point out all that. It's allowing the decree to be. Point out all that. There are other observations also which I'll point out.
We'll see on that.
Please, please. Please.
But 29, K. Abhinav Anand.
Respondent number 5 to 11 minute. I'm filing objections. 5 to 11.
Filing object. File there.
Not, this is
I
not
will file it
registry. You have to file the.
Copy
objection
also
in the-
third minute.
So file there.
Yes. I'm appearing for respondent number 13 to 15.
Well, I'll furnish fresh process to send a fresh notice to respond number 16.
Step to be taken in respect of unserved R 16.
And 6. December 30.
Lots, I appear for the BBMP in this matter.
Pertain to the encroachment on lakes in Bangalore and also Staramount Train. Several
Lots.
orders have been passed from now to they have to file the status report.
I'd specifically moved this court on the last occasion, my lords, because if my lordships may turn to the order dated 4/3/2020, my lords, of this honorable court. 4/3/2020, my lords.
Where is it?
4/3/20.
4/3/2020.
In which matter?
In 38401, my lords.
38401.
Yes, my lords. On 4/3/2020, there is an order which is passed by this court.
In this matter, I have filed 3 IAs for modification of the same order. I have annexed that order with my IAs.
You have annexed that order?
IA numbers 5 of 2022.
Copy is not furnished.
6 of 2022 and 7.
Copy are not served on them.
I've served the government.
On the petitioner.
Because earlier also this court rejected the contention. This impeding applicant, they want to maintain the lake. Court said it is unheard of. Just
May I
go
make my
through it.
submissions on this, my lords? My lords, on that order date.
No, anyway, he seeks recall of that or modification of that order.
Similar prayer is being made.
You have also made.
Yes, my lords. On
Then,
22
now you have served the
I'll
copy
go through
on
it.
him. He has to go through and he has to
I'll
make
come back.
submission.
Short date may be given so that.
In connected matter, he is a party.
My lords,
Therefore,
what I
it may
placed
be.
before this honorable
They are
court is-
connected because they will cast their shadow or light on the other matters.
Entire proceedings are not adversarial.
Please, my lords.
And in fact, one more submission, Lordship.
If I may briefly make a submission, what on 4/3, this, please.
In the last week of.
Yes.
In the last week of.
April.
In the meantime, whatever you want. Yes.
I appear for petitioners in
Yes.
30.1 and 30. And one submission, Lordship, I want. In 30.4, one memo I filed in the Mallathali Lake. Now IT employees are forming the layout inside the lake. You know, that,
No, next dating. no.
that
We'll
let
look
them
into it.
send the response to the BBMP for public. Memo is filed on 18th July.
some short date means so that I'll come back with the,
No, short. Yes.
23rd April.
please.
Number 31. Number 31. Mr. Ajay Kumar Patil, 14 percent.
Yes.
Nobody? Rule has been issued.
Please, my lords, please.
Hearing has to take place.
Yes. Because there is, every year, my lord, the same thing is getting repeated.
Education-
Admissions are being made contrary to merit, contrary to the judgments of the Supreme Court. Only consensual agreements are entered into and fee is fixed.
You
Whereas
fix
there
it.
should be a fee fixation committee.
Fix a date.
Please,
Which
my
date?
lords, and my only request is, my lord, an early date, because every year this is happening. And now CET results are likely to be, examinations are to be held next month. So if it can be taken up in the first week of April, any date which is fixed. And I also filed an IA.
17th we make it.
17th/4 we'll have that.
17/4. Please,
We'll try whether.
a little earlier date is all that I would request, my lords.
Even
Earlier will
17/4
not
we
be
are not
possible.
sure whether we'll be able to take so many matters. Huh? 17 is holiday.
17 is
19,
holiday.
19,
Then
19, 18.
18th.
18/4, my lords.
18.
Oblige.
Yes, your lordship's kind leave, Lord. In item 13, Lord, I was unavoidably held up in another court. Your lordships have posted it to tomorrow, that workers' case, Lord. I request one more week, Lord. I have some personal inconvenience tomorrow. Meanwhile, my lord, I have informed the other side, my lord, my land friend is here. I'm trying now, my lord, to see if I can persuade management to some,
Next week is
after 28th, any day.
After?
28th.
After 28th. Then it will go to 1st April.
Grateful. I'll try to persuade them, and my lord, if we agree, we'll move your lordship for disposal. Great.
Court officer. Court officer. Madam. Court officer. Court officer.
Lordships kindly. Lordships kindly, sorry. Sorry for submission, Your Lordship. Sorry, I should not be making a mention, but I'm requesting this honorable court. If serial number 62 is not reached, I would request that there's some urgency in the matter. At the end, it could be taken up. That's the reason I'm making a request.
Likely to reach.
Sorry, Your Lordship.
Let
I'm
us-
making I'm making the sorry for making submission at 2:30. I'm just requesting if it doesn't reach, there's some urgency. That's the reason I'm making a mention.
Number 20.
Please use the mic.
Madam, you be seated.
Please be seated. Kudvali.
My lord, the amount what was mentioned by the complainant was not correct, my lord. It is not the 29 lakhs that has been received by the accused number one. It is only 14 lakhs 67,707 that was credited to the accused number one. It is totally the amount what has been received by the complainant is accused is 15 lakh 13,613, my lord. I may be permitted to pass on the application that has been filed by the complainant.
And we will work out subsequently, dispute about the calculation and what is paid, what is not paid, what is due, what is not due, but what amount you are going to pay and deposit.
My lord, in that, my lord, out of 15 lakhs, I have already completed the order of this court by paying the 5 lakh rupees as ordered by this honorable court, my lord. And with respect to the rest of the amount, the accused did not have any amount and the SLP has been filed. I pray for 15 days time so that I may.
5 lakhs were paid when?
On 5/2/2024, my lord.
5/2/24.
5/2/24. And I have filed the compliance memo before this honorable court also, my lord.
My lord, around 45 lakh housing loan is there.
Anywhere the amount is reflected, which you are claiming. Which is the operator direction?
At page number 34, it is there, man. Page number 34.
Issued by the trial court. Where are the trial court's direction?
High Court order at page number 31.
32.
Basing upon the trial court order at page number 38. Order, page number 38.
38.
Yes. Order. IA number 9 filed by the plaintiffs under section 151 CPC is hereby allowed. Hereby directed the defendant 1 to 3 to deposit LI's policy amount of 5,45,906 received from defendant number 4 and death benefit amount of rupees 29,35,414 received from the defendant 5 before the court within 2 months. This order was on 9/1/23, my lord. Thereafter, the single bench of the Son of Court.
29 lakh is death benefit. What is that? Death benefit.
My lord?
It's a death benefits.
TCR. So
It's
this is
death-
the amount. you are supposed
My
to-
lord, this entire amount has been conferred on me, but it is not correct because the application that has been filed by the complainant itself before the trial court, they themselves have been admitted. I may be permitted to pass on the applications.
Submission itself is contrary to the order, my lord.
My lord, they themselves have been filed an affidavit before the trial court, and even the employer has also submitted the same thing before the trial court.
This order on being challenged has attained finality. Challenge is rejected.
My lord, the trial court order was challenged before the single judge that came to be disposed of, confirming the order of the trial court. Again, that order has been challenged before the Supreme Court. It is pending consideration, my lord.
Let it pend. Let it pend that way. But now, my lord has suggested what amount you are going to make now to seek adjournment, or we have to take
My
coercive
lord,
action.
right away, he doesn't have any money. 15 days time may be granted, my lord, so that he can report it to the court.
For what?
So that he will report it to the court about the status of the case as well as also.
That we
about
can
the-
get within 1 minute from computer for knowing status of the court in Supreme Court.
No, my lord.
Will you go by
we-
walk to the Delhi? to
We are
Delhi?
moving the matter before the apex court, my lord. It is likely to be listed because, my lord, the accused is a patient. He has been implanted with the stent, my lord. 4 stents have been implanted. And he was treated in the ICU also. I may be permitted to medical records also. He is not in a position to even.
What happened to that 29,35,414? Where it was parked? That money?
That has been settled accordingly to the loans, hand loans received with respect to the
loans.
treatment, my lord. And it has been detailed in the will executed by the deceased.
That will let after. Now there is an order. How much money is in your account now at present?
Nothing, madam. We have already settled in, favor of the hand loans received. And also there is a bank loan which has been taken and also for the treatment of the deceased, my lord. It is given
We
in the
should
will
direct,
executed by the
arrest-
deceased.
Arrest and detention. Then they will obey, otherwise not. We have seen these people. There should be.
This is
My lord, I may be
seventh
permitted to
adjournment,
pass
my
on the
lord.
will also.
What that means.
Now you are here, you are supposed to be here at 2:30 within this instruction to how much amount you are going to deposit. And it can't be less than 5 lakhs.
15 days time may be granted, my lord.
Excuse
Right away, he doesn't have any money, my lord. He is 70 years old, my lord. He is a patient implanted
Where
with
this
4
29
stents, my
lakhs
lord.
amount has gone.
29
Madam,
lakh and 5 lakh
my lord, it
45,000
has
also.
been
Both.
divided in favor of mother as well as the father. The father, what he has received, he can approach before this court. The mother has not made a party to any of the proceedings.
Now this 29 lakhs are given to you only.
Yes.
No, my lord, it is not absolutely given to me. It is only, I have only received with respect to 15 lakhs, that's all.
So
And 20,68,400 has been settled
We'll
in favor
require
of the
you-
complainant.
We'll require you to pay the part of the amount and will further require you to disclose to us as to how you have dealt with this amount.
Exactly, my lord. 15 days time may be granted.
No, right now, today,
Right now,
within 15 minutes.
my lord, I have to receive the day.
The present is a contempt petition in which the question of non-compliance of the following directions passed by learned single judge in order dated 31/5/23 arises and quote the paragraph, page 10 directions. Petition is hereby disposed of 1, 2, 3, 4, full stop. The directions are in relation to compliance of the order passed by the trial court on 9/1/23 in IA number 9 in the original suit proceeding number 1881 of 2018. Paragraph, the order of the trial court in its operative part, it says in the court, page 38, order. It is the aforesaid order of the court regarding payment of alimony. The complainant wife is required to be complied with.
And child also.
To applicant wife and the daughter, minor daughter,
Minor.
is required to comply with. Full stop. The accused appearing to learned advocate, Mr. So and so is unable to dispute that the amount of rupees 5,45,906 as well as the death benefit amount of rupees 29,35,414 have been received by the accused as directed by the trial court. Full stop. The fact situation today obtained is that as per the earlier order passed by this court, the accused has paid 5 lakhs to the wife and the. 5 lakh is
Received
deposited.
that money.
No, no, it has been
5 lakh,
deposited before the
it has
trial
been
court.
deposited before trial court, my lord.
You have not withdrawn it?
No, no, you have not received.
Why? We'll permit you.
My lord, but the order of this court was modified and said that the order of the trial court was subject to result of the appeal, and that was confirmed, my lord.
Around 45 lakh, my lord.
Because, my lord, the,
Order passed by this court on such and such date. The
my lord,
accused has deposited with 5 lakhs with the trial court.
Trial.
The said amount is lying with the trial
Trial
court.
court.
Paragraph. The complainant are permitted to withdraw the said amount, which the trial court shall permit after following the necessary procedure. Paragraph. When, yes,
my lord, the very suit filed by the complainant itself is to declaration to declare her as a wife before the court.
the husband, the accused husband cannot run away from its liability to pay the alimony to the wife and the children, and all the more to comply with the directions of this court. Full stop. In that context, we further direct that the further amount of rupees 5 lakhs shall be deposited by the accused on or before.
15 days time may be granted, man. 15 days time.
No. 1 week.
Is
Not possible.
is 70 years old, my lord.
Who is 70 years?
Accused, my lord.
Today is 20th, on or before 27th of, 28th of March. The trial. Full stop. In the event the directions are not complied with, the amount of rupees further 5 lakhs is not deposited as directed above, comma.
Arrest and detention. He runs the risk of being arrested and detained. Okay, arrest and detention is the minimum thing we can do in our system.
The accused shall be arrested and detained in the prison. Put up for further consideration on 15th April. Not further, further consideration part. Put up on 15th.
Number 33.
Your Lordship, appearing for the respondent board in this matter, Your Lordship. Similar point of law, there are several matters pending before this honorable bench which are listed on the 27th, Your Lordship. There are batch matters.
Other batch matters are posted on.
Yes, Your Lordship, on the
I don't
same
know,
point.
I'm not aware of what those matters are, not in this case. There are not two judgments, not of coordinate benches, taking somewhat divergent view, Lord. One, Lord, Honorable Justice Oka, the Honorable Chief Justice, his bench, took the view, Lord, that the directions given by the Honorable Supreme Court in the NGT matter did not issue any direction automatically you levy this 1 crore penalty on everybody. That's the view that the Lordships took, set aside those demands and remitted it back to the Pollution Control Board to issue notice here and then pass an order. In another batch of matters, my lord, before Honorable Justice Varale as the Honorable Chief Justice, in that bench, the matter arose, my lord, on a preliminary objection raised that there is an appeal available against this order. Therefore, you should go to appeal. So, my lord, though before the appellate tribunal, NGT.
NGT.
Yes, the
30,
action.
33.
Yes.
33.
Yes, Your Lordship, 33.
33A. Capital B, 33 capital B. So, my lord, these two divergent views are there. I, my lord, submit that the first judgment.
Where is the divergence?
The
Both they
divergence
can coexist.
No, my lord, in the first judgment, the Lordships, my lord, entertained the challenge, set aside and remitted it back. So, if the same thing is done in my case, I have no difficulty. But the other side is saying, don't entertain the writ petition, direct me to go in appeal. There is a particular observation directly on the point. In fact, the Honorable Court asked the other side, you are relying on an order of the NGT. Please show us in the NGT order where it is stated that you can impose this ad hoc imposition of 1 crore. And their lordships record that there is no such finding. But if it is some other date to be argued, not, I have no difficulty. Because if
Your
they say
Lordship,
similar matter is there.
I think similar matters are pulled.
The matter
They are
posted
pulled.
on 27th, Lord.
Yes, Your Lordship.
It is in pursuance of the Lord order passed by NGT. The compensation, the penalty has been imposed.
Interim
In-
compensation.
Yes.
Interim compensation.
Interim compensation. There, Lord, a committee was constituted.
Water Act.
Water and Air Act, both, my lord. These are industries, my lord, in an industrial area. If your lordships, my lord, would not mind, my lord, showing that judgment. What happened, my lord, was this. We had a consent under both the acts, my lord, we had to take a consent from the Pollution Control Board. So we had taken consent. Then, my lord, they had pointed out that there were some violations. So that matter was going on. And at that juncture, my lord, they took a step to cancel my consent. Immediately, my lord, whatever compliance was done, they restored the consent. Now, initially, what they do is they levy an ad hoc interim compensation of 1 crore with no notice, no hearing. Then, my lord, that was challenged. There was an interim order. Then, my lord, what they do is for the same period, they issue me another demand of 29 lakhs. Then they issue, in spite of the interim order, then, my lord, they issue one more corrected demand of 8 crores. Again, no notice, no hearing. The
Compensation. Interim compensation.
33A, my lord. Section 33A is the power which they invoke. That has no power like that. Kindly see 33A, my lord, of the Water Act.
NGT order empowers them to levy?
NGT order, my lord, says that in 100 industrial clusters, my lord, they make a list to say these are highly pollutable industrial areas. So in those areas, they said that actually the Honorable Supreme Court directed the NGT to do that exercise. Honorable NGT, my lord, directed the Pollution Control Board to do that exercise. But the orders say that they must go into individual case and then make an order. That's the direction.
Is it your case that since this order is made dehors 33 capital A, case will not travel to 33B and therefore writ petition lies?
I say two things, my lord. One is, that is the first submission.
No hearing at all.
That no hearing, no notice, nothing at all, my lord. They simply say, my lord, I don't know if I can say, in Kannada there's a saying, Yattitu andre kotke kattu anta. It means somebody just shouted that a bullock has given birth to a calf. So the other person who heard it said, yes, take it and tie it in the stable and we'll look after the bullock. This is something like that. Because they simply said, NGT said levy. So they say the only reason given is NGT has said so a levy. So it's completely mindless exercise. If they had given me notice, and in this case, my lord, the consent is reinstated.
Mindless.
So they'll have to give me a notice and I'll explain. And another thing, Lord, in this case, my industrial unit is located in Bommosandra industrial area. The NGT was concerned, my lord, with 100, they identified 100 areas. And
Within that it does not
it
come.
doesn't come. That is only Jigni. There's another place called Jigni in the same taluk, in Anekal taluk. So they identified Jigni as a place. my industry is not even in that cluster. Of course, if they'd given me notice, all of this would have been explained to them. So on those grounds, my lord, my submission is that instead of going into it in some great depth, these orders, my lord, may have to be set aside and they may treat this as a notice and I will reply and they can pass.
In some of the cases, we have treated them as the notice.
Yes.
There are few cases. There are some pattern judgments which you have made. Who appears for pollution control board?
I appear for the pollution control board, your lordship.
Yes. There are 3, 4, 5, 6 pattern judgments where we have held along with just Honorable Justice Varale Saab and myself. We
Yes,
have
your lord.
directed to treat these orders as the show cause notices and pass separate orders after having the say of the aggrieved.
One of them, my
That
lord,
we
is in
can,
the objection statement. My lord.
Those
One of
are
those
the
orders.
cases-
One you have
Yes,
produced.
in the objection statement in this case, 9914, at page 102, your lordships will get one of those orders. Treat these as,
Export has said, wherever they have unilateral, yes.
But your lordship may kindly have it on 27 because I do not have.
Yes, sir,
a copy
these-
also. Because
No, state
the
law. In my
in
case-
those matters which are posted on 27, the penalty has been imposed, compensation.
Not compensation.
Lord,
Penalty is
imposed in
Penalty
pursuance of the order passed by NGT, wherein Lord NGT constituted a committee to look into all these violations. The report has been submitted to the NGT. Thereupon, Lord, the NGT issued directions to PCB to take action against the violators.
Correct. After without notice, without a opportunity.
Then, Lord, they have issued notice.
Not notice.
Demand.
They have made order itself. Easy submission.
my lord, my learned friend, my lord, may not be appearing in this case because state is not a party in this case.
Not a part.
No, my lord, because the action
In
is
the-
only
your
by the.
last
court.
Rest of the matters, he was a part, state was a party.
In 33, serial number 33, Lord, it shows GS heard, but I have not received the notice.
ಇಲ್ಲ ನೀವು ಪಾರ್ಟಿ ಇಲ್ಲ ಸರ್
Is not.
WP
Other matters-
9914 ಅಲ್ಲಿ
Your lordship,
9914 ಅಲ್ಲಿ GS heard ಅಂತ ಬಂದಿದೆ.
respectfully, your lordship, if I may intervene from the board, these submissions were made before the bench. And there were few writ petitions which came to be disposed of by stating that there is an appeal remedy. In light of those disposals, several review petitions have been filed, your lordship. The same contentions have been taken by the review petitioners. And that being the reason I have asked for these two matters also to be connected to those petitions, your lordship. These are the same contentions being taken by the review petitioners on 27th, your lordship.
We said they have 33B remedy, therefore you can approach the appellate judge, the NGT, but till you approach, this matter shall not be precipitated in one set of orders. In other set of matters where there was no immediate coercive action, we said go before the NGT within particular period, relaxing limitation, etc. The third one is, we have read down these orders as the paternalistic orders of giving opportunity, etc. 3 types of orders we have made.
When there is no notice case, my lord, the law laid down is quite clear, my lord. There are cases where notice is given, not adequate notice is given. Notice is given, but opportunity of presentation case is not given. These are 2 categories where honorable court may probably say you're not availed it, so you go and appeal. But cases where no notice at all, those are cases, my lord, which call for interference is my respectful submission. And finally, my lord, during the pendency of the case in this case, there was an interim order granted. For the same period, they issue one more demand, first for 29 lakhs.
One more set of. Now, those orders are in review now. But the panel counsel says, see, the orders where we said that you should go before the appellate, the NGT.
NGT.
They are in review now.
The earliest order, my lord, considers this in great detail, my lord. And in fact, in one of the first of the orders in the second type, their lordship's attention was not drawn to this order. And in the second of those batch cases, their lordship's attention was drawn to it, but they took a different view.
Even apex court judgments are little in discordance, where right of appeal is given, where in even there, if principles of natural justice are violated, the right of appeal is no bar for maintaining the writ petition is one view. Another is, you can urge violation of the principles of natural justice as one of the grounds in the appeal.
Please.
Is another judgment, set of judgments of the apex court.
Yes, ma'am.
So there is some discordance. In fact, but there is one
Ultimately-
article by Nariman.
Yes, my lord, I am aware. My lord, the ideal.
Mounting inconsistency in the Supreme Court, heading of the article, Indian Bar Review.
Please. My lord, but what I'm submitting, my lord, is this. On factual aspects in these cases, my lord, the first round of cases, my lord, where this honorable court entertained the petition.
Your Lordship, there was a distinguishment drawn from those batch of petitions, and that subsequently orders were passed by stating that there is an appeal remedy and the petitioners were asked to avail the appeal remedy, Your Lordship.
27 matters are
Kindly see the order, my lord, the first of the orders which deals with this, it's at page 86 in the objection statement. Honorable Justice, Chief Justice Auka and Honorable Justice Ashok Kinigi, where, my lord, this is what their lordship say in, that is part of the record, my lord. At page 99, copies of such orders are placed. After going through the said orders, their lordships are referring to NGT order, my lord. We find that no direction has been issued by the National Green Tribunal against Pollution Control Board to recover or demand, should be internal page 14.
We have seen that.
To recover or demand environmental compensation, whether interim or otherwise, or environmental compensation charges. When we called upon the learned counsel appearing for board,
Oka Sahab said there is no such direction.
there is no such direction. Their lordships inquired, show us where it is. And the impugned order in this case, the only reason is there's a direction.
One aspect is not considered is, if one will travel to 33B, if 33A is attracted,
please,
not otherwise at all. If the order is made pursuant to direction of NGT, we can't say that it is made under 33A umbrella at all.
Because
That aspect
33A
is not considered
yes,
by us.
is only a direction regarding the removal of pollution and other things. They can ask them to repair it or close the unit.
There is no direction by the order of the NGT to levy anything compensation. So larger issues are involved. Hold the matters in classification. Till then, it has to
Orders by the competent authority under the Air Act or Water Act, which may be in the nature of a kind of expression of view and requiring the party to abide by that view, then it might not fall within the concept of direction.
Please. Please. It is possible that is
Or
the,
it is a decision. It is certainly not a decision, but it can't even be said to be a direction.
but I would only say, my lord, I would defer, my lord, to that to say that if the NGT has passed such an order and the Honorable Supreme Court, my lord, has affirmed those orders,
Then it is a direction.
then there is a direction there from the Honorable Supreme Court order.
the power to issue direction arises by statutes, by custom, by contract, by precedent. This fits into precedent.
So when they pass that order, in fact, the NGT order, my lord, talks of certain cluster of industries where this is there, and they say you must go into and examine. Even in the impugned order, they refer to that, my lord. The impugned order itself at Annexure A, they refer to that. The lordship has the amended petition at page 34, Annexure A. The amended petition.
So you are liable to pay interim environment compensation.
Yeah.
One.
Kindly see at page 35, my lord, second para.
case of normative basis for quantification of the interim compensation.
Second paragraph, this is the impugned order. Honorable NGT further directed to make assessment of compensation to be recovered from the said polluting units for the period of last 5 years, taking into account the cost of restoration and the cost of damage to public health and environment and the deterrence element. The scale of deterrence may be related to the period and the frequency of defaults, and such other factors as may be found relevant may also be taken into account. The tribunal has directed that pending assessment of compensation, interim compensation be recovered at the scale adopted by the tribunal in the case of Vapi industrial area in so and so, large industry 1 crore, medium 50 lakh, small 25.
It's a scale.
Scale. That means that is like a
The
thumb
maximum
rule.
that can be, anything between, it will oscillate between 2 points.
Yes, in this case, my lord, 2 or 3 objections was, one of the objections was that the flooring of the unit, they had not put concrete on it. A very minor kind of infraction, if at all we can call it. And what they did, my lord, they said, you are a large industry, therefore I'll apply 1 crore. And one more argument I have, my lord, in the previous page, if your lordships could please see at page 34, they're referring to KIDB industrial area, Jigini.
You said that, it
I'm
does not
not
fit
in
into
Jigini.
that. Three paternalistic orders we have made in matters like this.
Yes.
In them, you have also appeared.
Yes, my lords.
One is whether there is power to levy interim compensation or not. We have not considered. Perhaps Justice, the bench headed by Honorable
Was
Justice
considered,
Oka, Honorable Justice Oka was considered. There is another coordinate bench decision also.
Yes.
We'll come to that. The second one is the direction of the Honorable NGT is normative in quantifying and levying the compensation. It's not penalty.
It's not penalty.
Interim compensation. The 3 classes have been made there. And each of the classes, the amount specified is not pigeonhole amount. It is the maximum.
Yes.
Because the word used is
Yes, yes.
scale. Scale is interpreted by that way, by courts. Number 2.
Yes.
If it is a scale, why not 1 rupee? Why 1 crore rupees? The scale oscillates the matter oscillates between these 2 extremes. To decide where the oscillation pendulum has to stop, you have to hear the other party. Otherwise, you will assume that pendulum is on the extreme,
Yes.
which is not, it offends logic.
I understand. Yes.
Number 2, second aspect is of appealability of the order.
Yes.
You said in other day, 33B, etc.
It is.
When Honorable Ukasab was here. 2 questions will arise because of broad classification of the survey of the judgments of the apex court, where statutory appeal is provided, but the order has been passed in infraction of the principles of natural justice. Again, there are 2 more subclasses. The apex court said, in certiorari, there is no question of alternate remedy. This is one broad category, which Mr. Naganand had argued in some matters. You had argued in some matters. Number 2,
And Majority have also passed in order.
we have
similar
passed
to
that.
that.
We agree.
Yes,
Now we
yes.
are also not that consistent because it bit difficult. Many things will operate. Number 2 is you can go in appeal, urge the violation of principles of natural justice as one of the grounds. The second one is. Third one is to facilitate he traveling to the appellate body. You should not travel. You should not pull down him from his vehicle. So things have to be kept intact. He should be protected. This is yet another class of judgments. Yet there is one more class, which I was mentioning to Honorable Chief Justice, that is reading down these orders as the show cause notices, where he will have his say, then pass the order. This is how 3-4 patterns
That's,
emerge.
I would only make one submission. That's among all the classification methods. The right stance methods from my side would be the fourth classification where we have to, my lords, accepting the judgment of this court, read down the order as a show cause notice, and we are not changing on that. But my lords, with a small caveat from my side or from the board side, there are two kinds of compensation, my lords, which is, my lords, I should say that, my lords, this petitioner's case is a classic case, my lords, which could be argued even on 27th, where the connected matters are coming up. Here, my lords, what has happened is there's one element of interim compensation which has been levied based on two orders of NGT. My lords, that orders, my lords had stated, it's a scale. My lords, respectfully, my lords, the order does not say it's a scale. It is the only, I can show that, my lords.
We have read that word.
No, I will show that, my lords, how it is not a scale, respectfully, my lords, and how it is.
Even notwithstanding the terminology. That's your argument. Is it your case that the word scale is militantly absent in the order?
My lords,
Or
the
your
word
case is-
scale was not, my lords, I may be wrong, but my lords, my reading, my reading respectfully, my lords, the word scale, there are different terminologies which are used in the NGT order, my lords, which pertaining to the pollution capture level and other things. So far as the interim compensation is concerned, our stand has been consistent. Even the NGT records in its order that, my lords, we do not have to hear the petitioner at any point of time, for the simple reason that it is an interim compensation which we are levying today pending assessment. And my lords, that is the exact reason I'm saying that, my lords, petitioner's case is a classic case, is because pending that assessment, we've imposed that, they've come before this court, we have assessed, and, my lords, an extra AA, which has been subsequently been impugned here.
He need not be heard at all.
Lords, I can show
They
that.
are just asking. We are asking you. Because we have
That's
read
if you
in
ask
the,
me.
we have read in the law school that God had given an opportunity of hearing to Adam and Eve before punishing them in the Eden garden for eating the prescribed fruit. If you are wiser than God, then very well. This is how, yes.
That's
In Vapi case has been stayed by the Honorable Supreme Court. Again, if they had given me a notice, I have a copy of the
It
order.
is not about
That judgment
stayed.
itself is stayed.
My lords, here what has happened, my lords, there are multiple orders of the court which has been intermixed by multiple petitioners. My lords, that is why there's a foray of judgments which have gone on to contradict each other. My lords, my only submission is that, my lords, the interim compensation which has been levied, for that, my lords, we are following the, of course, my lords,
Stay of prosecution.
In Vapi's case, my lord, which is referred to in the show cause notice,
That is stay of
that
prosecution.
judgment is stayed.
Stay of prosecution.
Say of prosecution.
That's Vapi. We are relying upon 1038 of 2018, three orders, my lords, two interim orders for the purpose.
So that you can hear all of that.
What we'll do in 27? Today.
Yes, I'm ready to argue.
27th rest with along with rest of the matter.
Yes, my lords. That's in fact, my lords, the last of the judgments by this bench. That's of course, previous Chief Justice, my lords, is the right judgment. Of that, my lords, we have no qualms at all. We have to follow it. And that is why, my lords, if my lords may recall, I had said that, my lords, there is a solution which I had taken instructions, my lords, and telling them that this judgment has to be followed to the last word, and which, my lords, my clients also have agreed to it. The only difficulty is with regard to interim compensation. That's that I have to convince my lords that I don't have to hear. Of course, my lords is not wiser than God, but
Even 1 crore rupees.
my lords,
Regardless of the terminology, if you are asking him to shell out 1 crore rupees, should he not be asked, Mister, we want you to pay so much money.
yes.
Can you say why you do not want to? Why you should not be directed? That's how fairness operates.
Yes,
You see, John Rawls, justice as fairness. So in a famous book where he says, the government should act as a fair person.
Yes. Yes,
That is how.
That's here, the interim compensation, of course, my lords, I have to repeat it again on 27th.
27th.
I'll make my submissions on that point. That's only interim compensation, but the final compensation, that's whatever my lords have decided in another bench, that I would make a submission.
Twenty-seventh.
Grateful.
But interim order may kindly be continued.
Stand out to 27th. Full stop to be listed with other connected matters. Interim order They'll continue to operate till the next.
It will be one day later, my lord. I'm not available.
Those
on-
matters are posted on that particular day.
I'll make a request that day,
On
my lord.
that day
Not
you
in
can-
India on that day. I'll make a request.
On that day, we'll see
Please.
how it.
Grateful.
Series of petitioners for the same. I think we'll be addressing senior counsels.
Can join later.
No, but I think it will be addressed on that day, even without sir being there. We're confident on that.
So you will be safe.
Thank you.
You will be safe. You will have at least one opponent.
My lord, it can be disposed of very simply, my lord, without going into anything, because they're a statutory body, my lord. I fail to understand what resistance they can have to a person being heard in the matter before you may pass order. But there are some issues which they should, at least their mind may not be, they may not have applied their mind to that issue. I'm not saying any malafide or anything, but honestly, it may not have occurred to them. If only that given not notice, we could have, even if there was an order of NGT, they could have given us the notice, say NGT has made such an order. We are proposing to impose 1 crore. You want to say anything, please say. We would have pointed out and they could have passed the order. That's all that would remain. Great.
December 34.
Serial
But
number
this matter,
34,
no, your
last-
lordships,
the last
heard and
occasion.
asked us to file some minor matters, but of course that lordships was sitting in.
Yes. Last
Your lordships had
kindly,
asked us to file the synopsis
We have
on the
filed
last occasion. Of course,
synopsis.
your lordships were in a different combination then, where your lordships had heard us at length and your lordships had directed us to file synopsis, but my lord, we'll still,
So
we'll argue our matter again, my lord, because
Yes,
now, yes.
refresh the things at least.
But
My lord, this is a matter
the state
where,
has filed an IEA for vacation of interim order passed in this matter.
No, we are hearing on the main matter itself. Your contention is it is in the prohibited area.
Yes.
Therefore, they cannot undertake that
Yes,
activity.
yes.
You'll ask me kindly take the.
well, one kilometer, 1 kilometer, Kapatgudda Wildlife Sanctuary,
Absolute power. Within 10 kilometers.
which we had,
additional.
3 orders of the Honorable Supreme Court would make it clear.
Last may kindly take my written submission dated
No, no,
13.
our Hill.
Yes.
Let Mr. Kannur say.
My lord, Lord, at the outset, I must say, my lord, that this is not a case of either illegal mining or a temporary permit which has been granted, under which, my lord, number of judgments in Godavaraman's the apex court came up with, my lord. We were, my lord, given the lease for a period of 20 years on 10/5/2017. And, my lord, this Kapatgudda Wildlife Sanctuary
That order is 10/5/2017 order.
yes, ma'am. That is the lease which has been given to us for a period of 20 years, Annexure A.
Page
Annexure
number?
A, page 25.
It is for 20 years.
Yes, ma'am. Now, in the year 2019, this Kapatgudda Wildlife Sanctuary notification comes into picture.
Dated?
2019. I'll give the exact date. Now, prior to that, my lord, once when this,
Give
my
that-
lord, I'll just give that. Because there were earlier proceedings before this honorable court. I'll just give that date, my lord. Exact date I'll give.
That notification.
Yes, ma'am.
Issued under which section? Which?
Under the wildlife, section 26A of the Wildlife Protection Act,
On 16/5/2019.
15/5/2019.
16/5.
16/5/2019.
Section 26.
Beg your pardon?
Under section 26.
Lord, this is
26
under
it is.
26A, subclass 1, class B of Wildlife Protection Act 1972.
Yes.
Now, based on this, my lord,
they, my lord, suspended our, the lease. Against which, my lord, we filed writ petition, my lord, came up before Honorable Chief Justice, Justice Oak and Justice Govinda. There was an interim order and, my lord, a final order was passed saying that unless there is violation of the minor mineral rules, you have no jurisdiction to stop. Your lordship may kindly turn to page annexure B. The order passed by this honorable court
B
at
is
page 56, annexure B,
dated,
page
number.
56, 56, order dated 12/4/21.
Page number 56.
Yes, my lord, it starts at 56. My lord, if your lordship, my lord, turns to para 2, relevant page, my lord, at page 64, that is internal page 9, internal page 9 of the order. The first reason given in the said order is that in the meeting of the Gadag District Task Force Mines Committee, it was agreed that it is necessary to stop the mining activities within 1 kilometer from the boundary of Kapatguda. My lord's got it. Page 64 starts at 56, relevant portion. 64. The first reason, my lord's got it. Para 2, but on 64, I'll just, so that I'll only. The first reason given in the said order is that in the meeting of the Gadag District Task Force Mines Committee, it is agreed that it is necessary to stop the mining activities within 1 kilometer from the boundary of Kapatguda Wildlife Sanctuary. Therefore, the petitioner was instructed to stop the mining activity. In addition, it was also directed to stop mining in the sanctioned stone mining lease area. On the last date, we had directed the learned additional government advocate to take instructions whether all the leases subject matter of these petitions are valid and subsisting. Today on instruction, he states that the leases are valid and subsisting. After having produced the order impugned in WP number so-and-so, it must be mentioned here, the same does not refer to any statutory provisions or statutory rules which empower the District Task Force Committee or the state government to close all the activities of mining in a particular area, so long as the lease is granted to the petitioners under the said rules of 1994 are valid and subsisting. The mining activities on the base of the leases cannot be prevented or stopped. So, my lord, then paragraph number 6, hence the impugned orders cannot be sustained. The same are not supported by any provision of law. Accordingly, pass the following order. The impugned order at annexure hereby quashed. It's always open for the respondent to initiate proceedings for cancellation of the leases if they so desire. The writ petitions are disposed of. My lord, now after this, after the order passed by this court, my lord, without following, my lord, the object or the order, what this honorable court said, they again, my lord, suspend our the lease, my lord, on the same ground. We again approach this honorable court. This honorable court grants us an interim order and subsequently, my lord, allows the writ petition that is at annexure C. Annexure C, page 67. Annexure C, page 67. My lord's got it. Annexure C, page 67. My lord, if your lordship turns to para 7 at page 73 and relevant, my lord, as para 8 at page 74, internal page 8. If the impugned resolution is examined, my lord's got it, is examined, there is no change in factual matrix. In the earlier round of litigation, also similar contention was taken that the mining activities within 1 kilometer from the boundary of Kapatguda Wildlife Sanctuary. In the present case, the respondent authorities have come up with the case that the respondent state has issued a draft eco-sensitive sensitive zone notification. It is not in dispute that the draft notification is yet to be approved by the central government. Therefore, it is incumbent on the part of the authorities who has issued the show cause notice, so examine the reply, pass appropriate orders. It is needless to say that unless the concerned authority examines and reply and passes an appropriate order, and unless there is an adjudication in regard to the license granted in favor of the petitioner, the respondent authorities have no authority to stop the mining activities when the lease is valid and subsisting. The respondent, not the order. The respondent authorities are directed to examine the replies submitted by the petitioner and pass appropriate order. It's made clear that till the authorities examine the reply and pass appropriate orders, they shall not insist for stopping the mining activities. It will always be open for the respondent to initiate proceedings for cancellation of lease. Similar direction, my lords, have been given again by the Honorable Division Bench as was given on the earlier occasion. After this, my lord, they again pass a similar order. But now, my lord, I'll take your lordships directly to the operative portion of the order, my lord, passed by the senior geologist, which we have impugned before your lordships. My lord, may I request your lordships to take page 127, my lord.
Whether that was a case of draft notification,
My lord, now what has happened is,
whether notification is finalized now?
no, my lord, they have, the state has just on, in March, after, my lord, your lord, it was heard on the last occasion, now they have sent a proposal, now that has been sent. So, my lord, what the Honorable Supreme Court says is, once a proposal is sent under Rule 532 under the environment rules, my lord, then an eco-sensitive zone, ESZ, has to be issued. So, my lord, it is not as though, my lord, that there can be that it can be stopped straight away and right away, my lord, because even in Godavarman case, where in Goa, my lord, there was illegal mining, there, my lord, also they said the economics have to be considered, where there are a lot of people who are working. So, my lord, nowhere they have said that it should be straight away stopped. And, my lord, may I request your lordships to turn to page 127?
That notification which you said issued under 26A1B.
Yes, ma'am.
It is only a draft notification or a final notification?
No, wildlife. That is under the wildlife, declaring it as Kaput Gudda. After that, my lord, then they'll have to issue a ESZ, eco-sensitive zone, for which, my lord, the government has sent a proposal now that we have produced along with the synopsis, my lord, that has been sent. We have filed on 15th March 24. That, my lord, they have sent on 1/3/2024. So this is now, my lord, the government will declare an ESZ.
What is the effect of 26A declaration?
My lord,
where it is, which section says?
My lord, that it will be the Kapat Gudda, the wildlife sanctuary. That this is the wildlife sanctuary. These are the boundaries of the wildlife sanctuary. Then, my lord, whether mining activities till under what area, till what area it can be conducted, my lord, that the ESZ, my lord, the eco-sensitive zone, that notification has to be issued, for which the government, my lord, now on 1/3/2024, they have now, my lord, sent this proposal. My lord, along with this, these are the notifications. If I just pass on. These are the draft notifications.
You mean to say,
yes,
even post 26A notification,
yes,
mining activity can go on?
Yes, my lord. Mining activity can go on. My lord, in fact, my lord, what they say is that after, my lord, the central government, my lord, they have the powers to stop it if they find otherwise. Under Rule 5, my lord, they can do it. Under the Environment Protection Act, they can do it. But that has not been done. Otherwise, even what the Apex Court, my lord, also has held, that this rule, my lord, 532 has to be followed, my lord, where there is an expert body, what can happen, what cannot happen, my lord, that has to be looked into, and then orders will have to be passed. And from that date, my lord, even there, what, my lord, they say is that it can be in a phased manner. My lord, we are not doing something illegal, my lord. The mining, what we are doing is not illegal. And our, after environment clearance, we have, my lord, it was commenced much before all these notifications. So, my lord, the state suddenly, my lord, on a particular day cannot suddenly say that it stopped and now you move out of this place. And your lordship may see the impugned order, my lord, which is, my lord, which is before your lordships, my lord. Lordships, kindly, may I request your Lordships to turn to the impugned order at page 127.
They should have. If you say it is not. How section
26A.
29 of the act is construed by any of the high courts? 29 of this act.
Lord, Lord, immediately I do not have any information on any of the judgments. 29, your Lordships are referring to destruction, etc. in sanctuary prohibited without a permit.
Yes.
Without a permit, my Lord.
Read fully.
Yes, ma'am. No person shall destroy, exploit, or remove any wildlife, including forest produce from a sanctuary, or destroy, or damage, or divert the habitat of any wild animal by any act whatsoever, or divert, stop, or enhance the flow of water into or outside the sanctuary, except under and in accordance with the permit granted outside the sanctuary, except under and in accordance with the permit granted by the state chief wildlife warden, and no such permit shall be granted unless the state government, being satisfied in consultation with the board that such removal of wildlife from the sanctuary or the change in the flow of water into or outside the sanctuary is necessary for the improvement and better management of wildlife therein, authorizes the issue of such permitted.
Last explanation.
Once it is provided that where the forest produce is removed from the sanctuary, the same may be used for meeting the personal bona fide needs of the people living in and around the sanctuary and shall not be used for any commercial purpose.
Explanation.
Yes, ma'am. For the purpose of this section, grazing or movement of livestock permitted under clause D of section 33 shall not be deemed to be an act prohibited under this section.
Except the cattle for grazing.
Yes, ma'am.
Nothing will be permitted because it is a sanctuary.
Yes, ma'am.
In the sanctuary, if mining activity is undertaken, the sanctuary loses the sanctity.
My Lord, now, why then, my Lord, the eco-sensitive?
Nobody can enter also. See how the section reads.
Yes, ma'am. My Lord, if your Lordship sees even section 18, my Lords, of declaration of sanctuary.
Yes.
The state government may by notification declare its intention to constitute any area other than an area comprised with any reserve forest or the territorial waters as a sanctuary if it considers that such area is adequate ecological, faunal, floral, considered such areas of adequate so and so, geomorphological, natural or zoological significance for the purpose of protecting, propagating or developing wildlife or its environment. The notification referred to in subsection 1 shall specify as nearly as possible the situation and the limits of such area.
That is intent.
Yes, ma'am.
Fluctuation happens in 26 capital A.
Yes, ma'am. Declaration of area as sanctuary. When a notification has been issued under section 18 and the period for referring claims has elapsed and all claims, if any, made in relation to any land in area intended to be declared as a sanctuary have been disposed of by the state government, any area comprised within any reserved forest or any part of the territorial waters, which is considered by the state government to be of adequate ecological so and so for the purpose of protecting, propagating or developing wildlife so and so. The state government shall issue a notification specifying the limits of the area which shall be comprised within the sanctuary and declare that the said area shall be a sanctuary on and from such date as may be specified in the notification, provided that vary any part of so and so. So, my Lord, now.
Come to 27.
Yes. restriction on entry in sanctuary.
Even entry is prohibited except with a permit.
Yes,
If all these 100 and odd people along with their bulldozers and jumbo vehicles enter into this sanctuary, what should happen to the flora and fauna there? The very objective to protect them. What is sanctuary? Sanctuary is protection.
yes,
It is a like it gives a kind of asylum to them. That is the object of, if you undertake mining activity there, assume for a moment, I'll give an extreme example, where the sanctuary, the area declared to be a sanctuary pursuant to 26 capital A, is the area in which you are holding the mining lease. You mean to say you want to conduct the mining operation in the sanctuary itself?
My lord, the reason why I'm saying that is, my lord, because there is a thing that eco-sensitive zone has to be.
That's another thing.
Yes.
We will not go to that act at all. See this. Mr. Patil wants to say something. Yes, tell.
Yes, Your Lordship, that earlier it was a reserve forest. It has been declared all of a sudden 2019.
Correct.
Lot of developments are taken place and agitation are taken. There ultimately it has been declared in 2019.
Correct.
But the lease period has been given, subsisting lease. So that has how to close down that?
It goes.
No.
It is
That is our contention. No,
That's
it will
your
not-
contention, which appears
Yes,
to be
you are
not
denying
tenable.
that judgment, and
This is
all of a sudden it will not close.
this act is made to give effect to UN convention. This act is made to give effect to a convention to which India is a signatory.
Yes.
Pursuant to that, so many amendments have taken place.
True.
This is to protect the wild animals, the flora, fauna. That is the object of the act. Kindly see the purpose of the act to provide for
I
the protection
understand.
of wild animals. How you are going to protect the wild animals if your
But
machinery
what
is
we are
working
submitting
there?
is this. We are not coming in the way, my lord, of this or what. My lord, without again, my lord, giving us either an opportunity or, my lord, as honorable in TN Godavarman case, my lord, where continuously, my lord, with regard to these wildlife sanctuaries where they have held, that the guidelines issued on 7th February 2011 has to be followed in letter and spirit. Where, my lord, the notification they'll have to, my lord, follow. My lord, the central government, if on its own, my lord, under the powers under the Environment Protection Act, my lord, the central government has the power. My lord, now we, my lord, are not doing any illegal mining. My lord, we have a valid, that is what. And my lord, the impugned order before your lordships, impugned order before your lordships, my
I
lord.
have to interrupt because it is not mining. Quarry
Quarrying.
licenses given. The central government has no role to play. It has been granted by the state. And so far as Lord admitted position is this, Lord, the Kappadgudda Wildlife Sanctuary has been declared in the year 2019. There is no dispute about that. These quarry licenses are situated within 1 kilometer from the boundary of Kappadgudda Wildlife Sanctuary. The impugned notice has been issued in pursuance of the order passed by the Honorable Apex Court on 7/6/2022. I have placed that order before.
This is after 1 kilometer.
This is within 1 kilometer.
Within 1 kilometer
Yes.
of the periphery of the sanctuary.
Sanctuary. It is prohibited area, my lord. I have placed those judgment on record.
Even we
With
have
the
also placed those
compilation,
judgments.
you'll ask me kindly take my compilation dated 31/2024. Are my written submissions, Lord. In that I have extracted the relevant paras also.
Which is that judgment 2014 SCC? No.
No, 21. 2022 10 SCC 544. The state is relying on only on 3 orders of the apex court, Lord.
Which paragraph?
Lord, paragraph.
This is Godavarman only.
Godavarman in an IA filed.
Paragraph?
paragraph Lord 54 and 56.8. So far as
56.1.
54, Lord,
54.
page number 44.
There's 30.
My lord, that is 576.
576, internal page. Reported judgment 2022. CC.
No provision.
Yes, 576.
My lord's got it.
Yes.
Running page number 44. In our opinion,
Para 54,
54.
page 576.
Yes, so 576. 576, yes. That's what he is relying on.
In our opinion, the guidelines framed on 9/2/2011 appears to be reasonable, and we accept the view of the standing committee that the uniform guidelines may not be possible in respect of each sanctuary or national park for maintaining ESZ. We are of the opinion, however, that a minimum width of 1 kilometer ESZ ought to be maintained in respect of the protected forest, which forms the part of recommendation of CEC in relation to category B protected forest. This would be the standard formula subject to the changes in special circumstances. We have considered CEC's recommendation that the ESZ should be relatable to the area covered by the protected forest, but the standing committee's view that the area of the protected forest may not always be the reasonable criteria also merits consideration. It was argued before us that 1 kilometer wide, no development zone may not be feasible in all the cases, and specific instances were given for Sanjay Gandhi National Park and Gaindi National Park in Mumbai and Chennai metropolises respectively. We have urban activities in very close proximity. These sanctuaries shall form special cases. Then, Lord, may I take your lordships to page number 45, next page, 56.4.
That is 577.
Mining within the national parks and wildlife sanctuaries shall not be permitted.
Lord, there is total prohibition. And Lord, 56.8. In respect of sanctuaries or national parks, for which proposal of the state or union territory has not been given, as in this case, the 10-kilometer buffer zone as ESZ, as indicated in order passed by the court on 4/12/2006 in Goa Foundation, and also contained in the guidelines 9/2/2011, shall be implemented within that area. The entire set of restrictions concerning an ESZ shall operate till final decision in that regard is arrived at. Here also, Lord, ESZ notification has not been issued.
What is meant by 56.8?
0.8, wherever there is no notification delineating ESZ, eco-sensitive zone, in such cases, Lord, 10-kilometer
buffer zone
shall be maintained.
What shall be maintained means within that area,
yes,
the entire set of restriction concerning ESZ shall operate till a final decision in that regard is, or a final decision to be taken by whom?
By the central government.
Under what, what is this central 4/12/2006 Goa Foundation?
Lord, this is like this. This ESZ notification.
Till notification comes in.
Delineating this eco-sensitive zone. Delineating
a
the
wholesale way in 10 kilometers, no activity at all.
Activities. Then, Lord, this order has been further clarified in the subsequent order. The last may kindly take the next order in page number 100. Lord. Page number 100, para 65. This is an order passed on 24th, Lord.
Which clarified that judgment.
Yes, yes. 26, I'm sorry.
26/4/2023.
26/4. 65, page number 100. We also modify the direction contained in para 56.4 of the order dated 3rd June 2022 Supra and direct that mining within the National Park and Wildlife Sanctuary and within an area of 1 kilometer from the
Where are you reading?
56, page number 100 of my compilation.
This is the order passed by the Apex Court on 26/4/2023.
26/4/23.
Page number 100 of my compilation.
Page number?
100, 100.
Alright.
Para 65.
There is no page.
No 100 at all.
Lord, we have also produced those three
In our
judgments.
compilation, Lord, dated 31/2024.
10th January 24, we have also produced these three
31.
judgments.
31/2024.
That is different compilation.
Different.
No, it is also not there.
That is Honorable Justice B.R. Gawai's
Yes,
judgment.
ma'am. Please,
Yes,
yes. My Lord, may I,
Just a minute.
my Lord, may I, my Lord, prior to the para 61,
complain.
what has been clarified, my Lord?
One second, please. We'll come back to you.
Please.
Yes, yes.
Para 65.
Para 65.
Yes.
There's not so many paragraphs at all.
My Lord, I think your lordships are seeing the 28/4. One more order, my Lord. Prior to that, there is one more order.
For
No, this,
28/4.
my Lord, what my learned friend is relying was in 26/4. 28/4 only, my Lord, para, as your lordship said, only about 25 paras are there.
No, I have produced 3 judgments, 3 orders. Ade confused.
26/4.
Twenty-two 10 SCC.
26/4/2000.
No, that SCC citation.
My Lord, 2023 SCC online, SC page 504.
Three compilation reports.
That is, my Lord, 3 judges bench, my Lord, Justice Gawai, Justice Vikramnath, and Justice Sanjay Karol.
Adun tekti.
26/4. We are,
50 to 55.
ನಮ್ಮಲ್ಲಿರೋ para 65.
Yes.
Only 2 paras. I think.
Yes.
Para 65, we modify the direction contained in para 56.4 of the order dated 3rd June 2022 Supra and direct that mining within the National Park and Wildlife Sanctuary and within an area of 1 kilometer from the boundary of such National Park and Wildlife Sanctuary shall not be permissible. There is a clear prohibition.
Where are you reading?
para 65.
65, para 65.
65.
65. One kilometer from the boundary of such
Yes.
national park or and wild place.
Say complete embargo.
Complete embargo, my lord. And this was passed in respect of Goa Foundation. Thereafter, one more order has been passed.
In April, 10th of April.
28th of
2 days
April.
after-
8th of April.
2 days after this order, my lord, on 28/4/2023. But in this, para 9, please. Page number 105 of my compilation, para 9.
Where they clarify that para 65.
Further, it has been clarified. Well, Lordship,
We find that.
we find that.
Yes.
We find that directions issued in paragraph 65 of the judgment of this court delivered on 26th April 2023 are very much clear. It reads thus. We also modify the directions which contained in paragraph 56.4 of the order dated 3rd June 2022 and direct that the mining within the National Park and Wildlife Sanctuary and within the area of 1 kilometer from the boundary of National Park and Wildlife Sanctuary shall not be permissible. Then Lord, para 10. The perusal of the above para would reveal that the directions which were issued by this court earlier for prohibiting mining activities within a distance of 1 kilometer from the boundary of such national parks and wildlife sanctuaries, only insofar as the state of Goa was concerned, has been made applicable pan-India. So throughout India, Lord, this 1 kilometer has to be maintained. The aforesaid, next plan, the aforesaid question arose since in case of some of the national parks and wildlife sanctuaries, the ESZ areas are less than 1 kilometer. In some,
No, that question may not arise at all.
that would arise, Lord, because their contention is if the ECOZ notification is notifying less than 1 kilometer area.
Absolute bar. Absolute bar.
Notifying less than 1 kilometer. 1 kilometer. Say, for example, 500 meter has been notified. Beyond 500 meter, they are permitted and they'll take up a contention. That is exactly for the reason Apex Court clarified that even in the notified eco-sensitive zone, even if it is less than 1 kilometer, 1 kilometer has to be maintained as protected area. It has been clarified in this. May read, Mullah. The aforesaid question arose since in case of some of the national parks and wildlife sanctuaries, the ESZ area are less than 1 kilometer. In some, it is less than 500 meters, and in some other, it is even less than 500 meters. We therefore clarified that even in case where ESZ boundaries are less than 1 kilometer from the protected area, the ban on mining shall extend up to the distance of 1 kilometer from the boundary of such area. Now, the contention of the other side that ESZ notification has not been notified, therefore they have to be permitted within 1 kilometer holds no water.
And you say because that notification is not issued, this ban is absolutely applicable, is your point?
Yes, whether the issuance of notification is no relevance.
No relevance at all.
No relevance at all. And Milord, I have produced a list of quarry leases which are situated in what distance. Milord, as per annexure R1 of my written submission. Milord. In some of it starts from 32 meters. 32 meters from the boundary of wildlife sanctuary. So last may kindly take.
Come to para 24.
Yes. Para
23 and 24 of 28 April 2023 order.
Yes. We clarify that even if in a particular case ESZ is more than 1 kilometer, still if the concerned area where mining is proposed falls within ESZ, the mining activity will not be permitted even if it falls in an area which is beyond 1 kilometer from the boundary of protected area. The prohibition of 1 kilometer from the boundary of protected area is only with regard to the cases where the boundary of ESZ is less than 1 kilometer from the boundary of the sanctuary. Only in such cases, the ban on mining will travel beyond the ESZ area and cover an area up to the distance of 1 kilometer.
In any event, 1 kilometer.
1
is a must.
kilometer is the minimum area which we have to.
Regardless of the effect. Well, suppose you give a mining lease for 20 years. When the tenure is halfway through, you issue such a notification. For remainder of the period, what is the remedy available to him?
Blood in the lease itself, we have stated. Blood in
Where is
case-
that? Any condition is set that? I read that. Because when you give a lease, it is a right to property. Leasehold rights fit into Article 300 capital A of the Constitution because of KT plantation versus state of Karnataka.
Blood, so far as mineral rights are concerned, it vests with the state.
Right to mine them
It
with the
is not a
permission.
right to property, Lord. So far as mineral rights are concerned, it vests with the state. That is how, Lord, we grant the mineral quarry lease in a private land.
Correct. You are the owner
of the
in the soil up to the center of the earth. Okay, but you have leased them out to a citizen. That leasehold rights are treated as immovable property because it is extracted from the earth. What are, is it not curtailment of the right guaranteed under
The
300
future
capital?
extraction of minerals has been prohibited because of the environmental concerns.
Now there is cutting short of the tenure that lease period. For that, how you are going to compensate them? Assuming that all this has happened now.
Not in the lease itself. In the lease deed, there is a provision, I'll find.
Which is that condition?
Lord, the page number 37, last me kindly.
35 of?
37 of the petition. Lease deed is produced from 33, page number 33. Relevant portion is part 4, which is in page number 37.
33.
33 starts.
30 starts.
Such
liberties, powers and privileges reserved to the state government. Part 4.
Now, where does it provide for cutting short the tenure of the lease?
Blood, para 3, under part 4. Liberty and power to the state government to determine at any time by giving to the lessee licensee a notice in writing. The lease license, if the area for which the lease license has been granted or any part thereof is required by the state government for any public purpose, and a declaration under the signature of the director of the area, or as the case may be, the part of the area is so required, shall, as between the lessee and licensee.
So provides for compensation also. Next paragraph.
On determination of lease license under this power of the area under the lease license shall be resumed by the government, and the lessee licensee shall be paid such compensation as may be determined by the officer appointed by the government for the purpose.
So it is not that he is left high and dry.
Yes.
But in fact, in Goa Foundation case itself, in 2014, 6 SCC page 590, but here, though these are all illegal, my lord, what they say is that, my lord, so many people are working. You can't suddenly stop a person. As your lordships rightly said, my lord, there is some legitimate expectation even from the state government on our behalf.
Goa is
When-
considered in that judgment. The
Beg your
judgment which learned advocate.
My lord, I'll point out from that. I'll in fact, my lord, there itself, my lord, if your lordship, my lord, I will point out from that judgment itself where my learned, my lord, because we have also cited the very same 3 judgments, my lord, before your lordship, my lord, along with that thing. So, my lord, before coming to this, then I'll come to that judgment. My lord, if your lordship takes
Contractual rights stand extinguished or not? By virtue of either operation of statute law.
Yes.
Also by judges made law. Right?
And my lord, my lord, how they have suspended my lease is not as per this. They say under the minor mineral rules, section 8 to be, if a lordship sees page 127 of the, my lord, I'll
Chitti on contract.
please, my lord.
He says, where when the lease was entered into, it was lawful, but where because of the intervention of the law, it becomes unlawful. These are considered by Chitti on contract.
Now, but as your lordships also rightly said, my lord,
Maybe
and
one of the
where,
mode of
One of the
frustration
modes of frustration.
frustration.
He says frustration.
Frustration.
Chitti uses the word
my
frustration.
lord, now, what they say, my lord, even in that judgment which I just passed on to your lordships, my lord, where they say that even when this ESD is issued, my lord, it has to be considered, and my lord, it cannot be that it is done immediately. Why I'm saying that is, my lord, that guidelines 7/2011, my lord, which has been quoted in all these three judgments, has to be followed, and in ESC has to be declared, my lord, and then in fact, they, my lord, sometimes in a phased manner, they say, my lord, the judgment which has relied, I'll just point out certain points on the same judgment, my lord. If your lordship takes that first judgment, which the learned government advocate, my lord, relied on.
The question is, assuming that there is something in your favor.
Yes, ma'am.
In that, we'll assume that that judgment is in your favor. Later judgment which has been rendered after considering this judgment is considered.
Yes, ma'am. I'll just show that.
Very same
I will.
judgment, these orders are.
These are all, therefore I told you, very often I request the members of the bar to see that book by Rutvik Datta and Bhupendra Yadav.
On wildlife, I have that. I didn't get it. I have that book. I have that.
That law of forest.
Yes, law of forest.
He has compiled all the propositions of law given in a series of the judgment in Godavarman,
Yes.
Tirumal Pad. Therefore, these are not some judgments where the judgments do not operate on the doctrine of ratio decidendi. They operate as legislations.
I understand what your lordships are saying. Lord, even in the same judgment, my lord, your lordship may just permit me to, my lord, to distinguish it to, my lord, to show as to how, my lord, if your lordship, my lord, first sees, my lord, your lordship may kindly, that 3/6/2022, my lord, 2210 SCC page 544.
Dated?
So 3/6.
3/6/2022, my lord. Twenty 10 SCC, page 544. My lord, in this, your lordship, my lord, I would like to point out as to how this judgment also came into. My lord, your lordship may kindly turn to page 553, internal page 553 of the said judgment, paragraph number 5. My lord, because that also becomes important, my lord. That is only, that's how, my lord, I would like to, my lord, persuade your lordships, my lord, of course, subject to how your lordships would perceive it. Paragraph 5, my lord.
How it runs, starts.
Yes, my lord. The present set of applications. My lord's got it? No?
Yes.
The present set of applications arise out of a report of CEC dated 2011-2003. This report specifically pertains to Jammu and Ramgarh Wildlife Sanctuary. This sanctuary covers an area of about 300 square kilometers. The said report gives a horrific picture of ravaging of a protected forest, mainly by private miners, mostly with temporary working permits, obtained from the government agencies. The following recommendations were made in this report. My lord, I'll just stop at this, my lord, because this I'm only trying to say as to how, my lord, the Supreme Court, why, my lord, they came up with this order.
How many employees are employed in your industry?
But now there are 80 people are employed.
18.
Each
Mine.
mine.
There are about each of them, my lord. There are quite a few of them listed.
7 euros.
7 are there. And my lord, then your lordship, my lord, kindly turn to page paragraph 52, my lord.
In
Paragraph
rest of them also
56.
18.
Beg your pardon? Beg your pardon?
Rest of the matters may not be possible because this might go on. We'll distribute.
Don't disturb, we are in the mid of the hearing.
My lord, your lordship may turn to page 5.
Whatever date they want.
The rest of the board is discharged, date to be assigned and uploaded in the website.
Para 52.
My lord, 56, my lord. And my lord, prior to that, may I only request your lordships, my lord, para 53.
Yes.
My lord, may I request your lordships to take para 53, my lord? Para 53. We have also referred to the guidelines dated 9/2/2011, which give a detailed procedure for evolving of ESZ and identification of activities that could be carried on in such zone. The order of this court in Goa Foundation in so and so is also contemplated issuing of direction so and so. Lord, I'll stop there. Then, my lord, para 56, 56.1. My lord, para 56, that is at page 577. Each protected forest, that is a national park or wildlife sanctuary, must have an ESZ of a minimum 1 kilometer measured from the demarcated boundary of such protected forest in which the activities proscribed and prescribed in the guidelines of 9/2011 shall be strictly adhered to. For Jammu or Ramgarh Wildlife Sanctuary, it shall be 500 meters so far as subsisting activities are concerned. My lord, this 56.4, which my lord, dear lordship sees, mining within the national parks and wildlife sanctuary shall not be permitted. So, my lord, this has been modified, and my lord, that is in 26/4/2023.
No, 56(4) to be read with 56.8.
Yes, ma'am. That has been subsequently modified in the 28/4/2023 order also.
Correct.
My lord, but before that, my lord, 26/4/2023, my lord, I would, my lord, request your lordships to the subsequent judgment, my lord, 26/4/2023. My lord, here also, my lord, they say that whenever it appears, my lord, I'll point out the relevant para, my lord, 50, where they have given the proceedings. My lord, 9/2/2011, my lord, has been extracted in para 40.
In fact, from judgment to judgment, it becomes more restrictive.
No, my lord, what has happened is this, my lord. Because here, I will only, my lord, because in view of now the notification being issued, my lord, now if your lordship turns to para 54, my lord, 55, my lord, page, my lord, in our thing, it was 70. In their, my lord, the compilation which your lordships are seeing from their thing, 26/4/2023, para 55, my lord, para 55.
In fact, Mr. Kannur, 28 April 2023 judgment puts everything in black
To
and
rest.
white.
My lord, I'll come to that. If your lordship just bears with me for a while, my lord, because this is, my lord, how they say as to and how an ESZ has to be, my lord, issued. My lords may take para 55.
55.
Yes, my lord.
In so far as.
Yes, my lord. In so far as direction in paragraph 56.1, my lord, that is of 13/10/2022 order, my lord, which I read, is concerned, a perusal of various orders would reveal that this court has not directed any minimum area from the demarcated boundary of such protected areas. The area to be declared as ESZ cannot be uniform and will be protected area specific. In some cases, it may be 10 kilometers on one side and 500 meters on the other side. In certain cases, it may not be possible to have a uniform minimum area by virtue of interstate boundaries or a sea or river beyond one side of the protected area. In case a detailed procedure is required to be followed as prescribed under Rule 5 of the 1986 rules, which we have already referred here in above, we find that once such a notification is issued, after following the procedure prescribed under the 1986 rules, the ESZ will have to be as per the said notification. Para 56. It's further to be noted that as required under sub-rule 3 of Rule 5 of the 1986 rules, before any final notification is issued, a draft notification is required to be published in the official gazette and in such other manner as the central government may deem necessary from time to time. Any person interested in filing any objection to such a draft notification is entitled to file objection within a period of 60 days from the date of publication of the draft notification in the official gazette. We find that the central government can be directed to give a wide publicity, my lord, your lordship may note this, my lord, to the draft notification so that all person interested have knowledge about the issuance of such draft
They
notification.
can file objections. That
Yes, my lord. My lord, here we have not been given any opportunity, nothing, my lord. It is pertinent to note that after following the aforesaid procedure, my lord, further, the matter is placed before the expert committee consisting of 13 organizations having expertise in the relative field. As such, before an ESZ area is specified, various factors are taken into consideration. These are various factors which will determine the ESZs for a particular protected area. The circumstances may differ from one protected area to another protected area. As such, we find that the direction which prescribes a uniform 1 kilometer ESZ requires to be modified. So, my lord, now when they have sent a proposal, now they will issue an ESZ. My lord, they will, my lord, provide us the opportunity of filing our objection, my lord. And once, my lord, the expert committee looks into it, they say 500 meters, 400 meters, 1 kilometer, or 1.5 kilometers. And once, my lord, they say, and they may at that time, my lord, may give us some time to, my lord, to move out. They may give us that from on so and so date, you have to stop all the activities. So, my lord, that would give us an opportunity, my lord, at least contestant to be alive as on that date. Then, my lord, and then paragraph 61, my lord. Now, this becomes important for this reason, my lord, para 61. We are therefore inclined to allow the present IA. The direction in paragraph 56.1 of the order dated 3rd June 2022 is modified and clarified that directions contained therein would not be applicable to the ESZs, eco-sensitive zone, in respect of which a draft and a final notification has been issued by MOEF and CC, and in respect of the proposal which have been received by the ministry. My lord, I'll pause here for a moment. My lord, why this is being done is, my lord, to see, my lord, because the Honorable Supreme Court itself says it could be 500 meters on one side, it could be 10 kilometers on one side. We cannot prescribe a uniform thing that it has to be 1 kilometer. So, my lord, it is they, my lord, who will look into this. And then, my lord, now since they have now come up with the proposal, which, my lord, with our synopsis we have given, the government, my lord, your lordship may kindly see that, my lord, what proposal now they have sent. So now, my lord, once they send the proposal, we'll be given an opportunity, my lord, for looking into that. This, my lord, your lordship, my lord, then 28/4/2023.
Come to 65. Please come to 65.
Para 65 of, yes,
It's an absolute embargo.
26/4/2023. Yes, ma'am.
Absolute embargo. They have
We
said.
also modify the direction contained in paragraph 56.4 of the 3rd so-and-so and direct that mining within the national park and wildlife sanctuary and within an area 1 kilometer from the boundary of such national park and wildlife shall not be permissible. Shall not be permissible, my lord. They have not said that it is from with immediate effect, my lord. They have not said so. My lord, all this is because they say 9 to 2011 you follow, which, my lord, they say they prescribe. The Apex Court says follow Rule 5.3. My lord, these could be for the new ones, not for the existing ones. This, my lord, could be for the new proposals and where, my lord, if there are temporary, not ones which are already existing. My lord, then 28.
The word shall be necessarily to the existing ones. It cannot be anything
My
else.
lord,
at
this
all.
again,
Thereafter, again, it has been clarified. in
that
the
I'll point out. I'll point out.
Yes,
I'll
after.
point out. I'll point that out.
next judgment.
Next judgment.
Yes, my lord. 28 for, my lord, the same judgment we have also produced, my lord. So there is no running away from that. We have also produced all these 3 judgments. My lord, paragraph 24 now. The prohibition of 1 kilometer from the boundary of a protected area is only with regard to the cases where the boundary of ESZ, my lord, your lordship may kindly see this, my lord. To cases where the boundary of ESZ, my lord, ESZ is mentioned here, there is no ESZ. Eco-sensitive zone is less than 1 kilometer from the boundary. My lord, what they say is, my lord, where if it is 500 meters or something, if it is less than 1 kilometer, then that 1 kilometer will apply. Lord, your lordship may kindly see this, my lord, para 24.
The prohibition of 1 kilometer.
My lord, all this pertain to an eco-sensitive zone being issued, my lord. If there is an eco-sensitive, my lord, in our thing, they have issued a, my lord, as your lordships also put a question, my lord, when a lease has been given, my lord, I am doing as this honorable court, my lord, on 2 occasions. In fact, my lord, this honorable court granted as an interim order against which, my lord, the state filed an SLP. My lord, the honorable Supreme Court, my lord, did not vacate the interim order. My lord, because if it was so, my lord, on the face of it, my lord, if it was illegal, the honorable Supreme Court would have straightaway away stated that the interim order is vacated. The honorable Supreme Court said, go and file an application for vacating stay, which, my lord, they have filed, and that's how we are before your lordships. So, my lord, all these years, by orders of this honorable division bench, my lord, which we are there, eco-sensitive zone, my lord, now if your lordship sees the proposal sent by them, my lord, now, my lord, that is, this is the draft which I just gave, but the cover page, my lord, is along with our synopsis, my lord, which we have given, which now they have sent, my lord, the proposal. So, my lord, that paragraph which I read, my lord, at that time was, once, my lord, that this is set into motion, my lord, then the rules, my lord, under the Environment Protection Rule 5.3, which has been relied on by the Honorable Supreme Court itself, as to how it should be taken, my lord, I should be permitted to file. My lord, the eco-sensitive zone, my lord, it is not the same in all the wildlife sanctuaries. My lord, it could be 500 meters, it could be more. Or, my lord, the central government, even now, has the power, my lord, to immediately say that this is declared and it can be done. That has not been done. My lord, where am I supposed to go, my lord?
One paragraph of the apex code covers pending finalization by the central government itself. Once proposal is sent, the restrictions are.
In fact, my lord, in fact, the apex court also says that there is a lot of confusion in this, and that is why we are passing orders again and again, my lord. That is the reason why, again within 2 days, my lord, if your lordship sees from 26 to 28, again within 2 days, my lord, the Honorable Supreme Court had to look into it. So, my lord, now once they've set the law into motion, Lord, let them complete within, your lordship may direct them to complete it within 1 month or whatever time, Lord. If our objection, we don't need 60 days, which has been provided. We'll file, let them.
Para 54 in the first judgment.
54. Even these restrictions operate.
Irrespective
of finalization by the central government.
Lord,
and these are as my lord has already put it.
Yes.
In fact, these are cases which are rendered frustration because of the legislative intervention, judicial intervention.
Yes.
This is case becoming a contract, becoming impossible of performance because intervention of the highest court of the country.
Yes, I, my lord, bow down to that, and my lord, I will, I'm not, my lord, saying anything against the proposition which your lordship said, my lord, it's absolutely correct. What I'm saying is this, my lord. If they do it, my lord, then I am not, my lord, if suppose this has been done, it has been declared as an eco-sensitive zone, I cannot come before your lordships and say that since I already have a contract, they cannot do this to me, my lord, where that frustration comes, and what was legal or lawful earlier, by the act of a legislature or by a judgment passed by the apex court, which also becomes a legislation, as your lordship said. My lord, I have no case then. I will, my lord, I cannot then come and say that in spite of this being declared as an eco-sensitive zone, this, since I have a contract and I have a lease for 20 years, I should be permitted. No, my lord, I cannot say, and I will not say that. My lord, even I understand, my lord, but the eco-sensitive zone, my lord, when they have now set it in motion, and when the Supreme Court itself says that when that has been done, then this 1 kilometer rule will not apply, my lord, because it is for them to say as to how it is to be done. If it is not done, I can understand.
No, I would like to make one submission here. Irrespective of declaration of notification of this eco-sensitive zone, 1 kilometer has to be maintained. Is the judgment of the apex court, para 23 and 24 is very clear, lad, in the last compilation, last judgment of my compilation.
April 28.
Yes, Lord.
111 and 112.
Yes.
We clarify that even if.
We clarify that even if in a particular case, the eco-sensitive zone, that means notification has been
Not issued.
is more than 1 kilometer, still if the concerned area where mining is proposed to fall within ESZ, the minimum activity, mining activities will not be permitted. Then Lord, 24, the prohibition of 1 kilometer from the boundary of protected area is only with regard to the cases where the boundary of ESZ is less than, even
1
if it is
kilometer.
less than 1 kilometer,
Or
1 kilometer
500
has to be
meters.
maintained.
Yes, my lord. Now my lord, at the cost of repetition, my lord, your lordship, my lord, at my own thing, my lord, if your lordship permits me to just read these two paras once again. I'm sorry, my lord, at the cost of, we clarify para 23 that even in a particular case, the ESZ is more than 1 kilometer still. My lord, the ESZ is not here as yet. If the concerned area where mining proposed falls within the ESZ, Lord, here the ESZ is still not there.
Different case.
Beg your pardon?
It's not applicable to your case at all. It's
Yes.
a different situation.
Yes, Lord. And
Other point which he has said is applicable to you.
Yes,
This is a different scenario.
different scenario. Then para 24 says,
Also, he will not be applicable.
That is the to be read.
Lord, and para 24 says, prohibition of 1 kilometer from the boundary of protected area is only with regard to cases where the boundary of ESZ is less than 1 kilometer. So if it is less than 1 kilometer of an ESZ, first there has to be a ESZ, eco-sensitive zone, my lord, there has to be a notification. If it is less than 1 kilometer, then 1 kilometer apply. My lord, in our thing, ESZ is not yet been done. My lord, what I'm saying is, my lord, can this court, my lord, this honorable court will have to balance the equities, my lord. I'm not saying for a moment, my lord, that this cannot be done. This ultimately, it will happen. They will do it. They will give us time. And my lord, time has to be given for us to move out. Lord, they cannot come one day suddenly and then say, my lord, that's why this honorable court also, my lord, have protected us in this matter, though it has been from time again, my lord, they've been saying about this 1 kilometer. Lord, I understand if suppose the state does not take action for a long time, Lord, it will inure to my benefit. But your lordships are there, my lord, and now since they have done it, let them complete it within that time. And till today, my lord, we have been protected, my lord, by this honorable court, and even my lord, the honorable Supreme Court did not vacate the interim order. And not this, in fact, your lordships have issued rule in this matter.
Honorable Supreme Court believed that High Court will follow its directions.
To hear the matter, no, my lord. That is not what it was said. My lord, if that was the intent of the honorable Supreme Court, my lord, the honorable Supreme Court would have said that the interim order is vacated. My lord, that is not what the honorable Supreme Court says.
Lord, along with my compilation, I have produced
Yes, the
this.
matters.
So, my lord, the honorable Supreme
All
Court
the
says,
is-
go back to the High Court, file an application for vacating stay, and the honorable High Court is, my lord, requested. My lord, as your lordships are aware, my lord, the Supreme Court cannot direct your lordships. They can only request your lordships to consider that application for vacating stay.
Your lordship,
They are not posted today.
same in this,
In the list itself.
in this very case, I have filed this. Same case, it ranges from 32 meters from the boundary of this notified wildlife sanctuary. 32 meters to 700 meters.
No, my lord, the one question, my
Even
lord,
assuming-
your
even
lordships have to
assuming today-
consider, your lordships will have to consider one question, my lord. Now, whether the state has the power to, my lord, straight away suspend my lease, my lord,
Yes.
or is it the central government, or is it the Ministry of Environment and Forest? Once, my lord, the state sends the proposal of that these are the sanctuaries, and my lord, they set the law in motion for issuance of a eco-sensitive zone. In that regard, whether the state, my lord, can now say that, or it is for the central government and Ministry of Environment and Forest to say that, my lord, when the whole thing revolves around the eco-sensitive zone.
My answer to this is, Lord, these are the quarry leases granted by the state government. State government is empowered to.
My lord,
cancel
that this honorable division bench says that if there is any violation, my lord, that is the reason why I said, your lordship may kindly see page 127 of the writ petition, my lord. On what ground, my lord, they suspend, my lord, that may be important for this reason. Your lordship may kindly, my lord, turn to page 127, my lord, for a moment.
Of the petition.
Yes, my lord.
part of the.
Part of the writ petition, the impugned order, my lord, your lordship may kindly see, my lord. Under what provision, my lord, they have suspended, my lord?
127.
Page 127. That is the operative portion of the order, my lord. I will not already too much of your time we have taken, my lord. My lord, in exercise of the powers conferred in the writ petition, my lord, the impugned order, my lord. That is annexure E, my lord.
Of the original petition.
Yes, my lord. Original petition. Annexure E, 5/12/2022. This is the order which is impugned before your lordships, my lord. My lord's got it.
120.
Page 127. English translation, page 127. Lord, for a quick reference, my lord, can I just pass this one? The learned government advocate may not really dispute that. My lord, what they say is, in exercise of the powers conferred under Rule 8K2 of the Karnataka Minor Mineral Concession Rule 1994.
That's the impugned order.
This is the impugned order. So, my lord, now this your lordship may kindly see, my lord, 8.2, my lord, rule of minor minerals, my lord, under which they passed this order.
Okay.
My lord, 8K of the minor mineral, my lord. If your lordship sees the Karnataka Minor Mineral Concession Rules 1994,
Eight K two here.
yes, 8K2. Now your lordship may see the minor mineral thing, my lord. If it falls under this, my lord, I have no case, my lord. I will not.
Perhaps apparently it may not fall into that.
Yes,
but it falls into the directions issued by the apex court.
Lord, that I have.
Assuming that it does not fall.
There is a reference of that order.
Order
Very
also.
rule. Very.
My lord, that I would.
ನೀಡುವ ತೀರ್ಪು 7/6/22ರಂತೆ.
Out.
That judgment is also referred.
Yes.
So, my lord, this order passed under this particular provision, which, my lord, the Honorable Division Bench on earlier 2 occasions also said that the state government, if there is any violation of the provisions of the Act, my lord, minor minerals, or any of the violation of the lease which has been granted to us, the state can take action.
To this directions of the apex court have to be superadded. We have to read.
My lord, your lordship may read. My lord, for a moment, I'm not saying, my lord, that's why we have produced those 3 judgments. My lord, what I'm submitting is this, my lord. Why I said, my lord, the Honorable Division Bench of this court, my lord, because that was the same contention of Kapat Gudda 1 kilometer, my lord. That is, all these orders were there even when when this Honorable Court heard the matters. All that I'm saying is, my lord, all these in this judgment, the directions are, my lord, where an ecosystem. Otherwise, my lord, my submission, my lord, I'll just take 2 more minutes, my lord. My submission is this, my lord. If the whole provision of the Environment Protection Rules, my lord, Rule 532, which, my lord, the Honorable Apex Court, my lord, extracts in detail, my lord, if that is not to be followed, and, my lord, if it is given a go by, my lord, then how, my lord, even the principles of natural justice, or, my lord, the rule of law, my lord, where has it been? My lord, the Honorable Supreme Court has not said everywhere it has to be done. They say in an eco-sensitive zone, my lord, wherever the eco-sensitive zone, there's notification, my lord. Your lordship may only consider that. Lord, I'm not saying that they do not have the power. I'm saying that let them complete the exercise which they're supposed to do as per these rules, and as, my lord, contemplated by the Honorable Apex Court itself, which, my lord, in all the judgments, they rely on the guidelines, my lord, 7/2011, which also says that how it has to be done. So, my lord, unless they do that, and now, my lord, now if suppose it is stopped, and tomorrow, my lord, if it is said that beyond 1 kilometer or beyond so and so or whatever it is done, then what happens to my mining, my lord, if that is done? My lord, then the exercise which is being undertaken now, my lord, is rendered totally redundant, my lord, now what they are doing. My lord, if the central government, my lord, I'm making this submission, my lord, that if the central government, my lord, if your lordship even directs the central government to look into it immediately, and if the central government straight away says, now in view of this, my lord, then I have nothing, my lord, I cannot come before your lordships at all. If the central government, my lord, that also the provision is there under Rule 3, my lord. May I just take your lordships to Rule 3, my lord. Section 3, my lord. my lord, the section 3 of the Environment Protection Act, my lord, it is not as though the state government does not have the power. I mean, the central government. Power of the central government to take measures to protect and improve environment. So, my lord, it is the central government which can do this. My lord, if in case, my lord, if it is to be held that it is taking a longer time, like invoking the emergency provisions, my lord, in a similar way, there is a provision, my lord, which the central government can issue. My lord, the section 3, my lord.
So your contention is state cannot do that at all.
Yes, ma'am. It is if
But Central Supreme Court says the state government, union territories and all authorities shall implement these
no, my lord, it
directions.
is, my lord, but
Not
what they
not
say is
only
the
that.
EAZ,
One
my lord, the
simple-
EAZ eco-sensitive zone is not issued by the state government. State government can only, my lord, say the protected wildlife sanctuary, they can send the proposal. It is a Ministry of Environment and Forest which has constituted a committee. They will, my lord, then declare an eco-sensitive zone. The standing committee there, my lord, they will look into it. An expert committee is there, that which the Honorable Supreme Court itself has said. In fact, my lord, all this have come because your lordships are aware, my lord, this Godavarman case is continuously, it's going on, my lord, this every other day some applications are being filed and it's going on. So, my lord, all this your lordship may kindly see. It is with regard to my lord, then your lordship may kindly see Rule 5.3, my lord. This is section 3. The central government, they can do it.
I cannot understand, my lord, how this, the learned council is arguing this, because
Lord, I am not here to make my learned friend understand, my lord. My submission is before your lordship, my lord. Otherwise, after the arguments are over, I'll probably go to his chamber and try to explain to him, but not now. Now, my lord, I'll address your lordships, my lord. He may not understand, my lord, but that is not my job to make him understand, my lord. I'm here to convince your lordships, not him.
For this reason, my lord, now what is sought to be cancelled is a license, quarry license, granted under Karnataka minor mineral rules.
Under
And
what
it has
provision? Then, my lord, he
Let
has
me
to say
make-
under what provision he is cancelling it.
Let me make my submission. Now he is saying, Lord, this quarry lease cannot be cancelled. We have contemplated cancellation of quarry lease under Rule 6.3 of Karnataka Minor Mineral Concession Rules. Rule 6.3 empowers the state government to cancel the lease. There is a direction by the apex court, Lord. Here 8K empowers the state government to take action when there is a violation of Lord, the quarry plan.
Yes, if they do that, my lord, I have no case. That is what this honorable division bench has
I am
said.
making my submission, sir, please.
Now cancellation is of license,
License.
not lease.
License in Patta land. License will be granted in Patta land, in government. land,
Lease
it is
will be government lands, it's a Patla land.
Patta. Therefore, we cannot invoke Environment Protection Act. The state government is invoking, the concession is by the state government invoking this provision. There is a special enactment.
They suspend our lease under Rule 8K2, not the license.
Even assuming, Lord, 8K.
It's not a Patta land, it's a government land.
It is a Patta land.
Patta land.
Patta land.
Patta land.
Then it's not a case of lease at all.
License.
Though license it is.
License.
That license under Rule 6.
Rule 32.
32.
32 of minor mineral.
And 6.3 is power to rescind the.
General conditions of quarrying leases, my lord, that is Rule 6. Lease and license.
All.
Lord, my only humble request to your lordship, my lord, is that since we have, my lord, we have been given, this has come into picture after the lease has been given to us. And my lord, we have been continuing and we have continued today. My lord, straight away, without giving us time to either vacate or whatever, my lord, it cannot be with immediate effect, my lord, it should not be done. We should be given time, my lord. This is not, my lord, a case where a temporary permit or we are doing some illegal mining. My lord, it is like this, my lord. If suppose, my lord, I have come into something under a void document, or I have played fraud and I have got it. And after that, if I claim equity, my lord, then this court has frowned upon it and saying that you cannot claim equity. Even a student, my lord, after completing third year, fourth year also, but if his admission at the initial stage itself is held to be invalid, my lord, he can't claim equity. My lord, I am not claiming, my lord, because this is not a case where we have not come into a thing which is illegal or anything, my lord. Because till today, they have not found anything my lord, if your lordships, one submission. Nothing illegal has been found
No,
to
no,
be
they are
done.
not saying any.
Yes, no, they are not said
only
anything.
thing Supreme Court has said like this.
Yes,
This is what they are saying. We have to consider that argument. What you say is what Supreme Court said needs to be confined to that eco-sensitive zone notifications only.
Yes,
unless that notification is issued. Rest of the things will not apply. Is your
yes, no.
essential.
So once, yes, no. So once, so Lord, I should be otherwise this entire exercise, entire these rules, my lord, will become redundant, my lord, because then there can be one blanket direction that from today onwards there will be no thing at all. Lord, in fact, notification which we gave to your lordships.
You are trying to say that no power to cancel.
Beg your pardon.
They don't have power to cancel.
But they have the power to cancel under the minor mineral rules if it was rule 8K2.
Power to grant itself includes power.
My lord, but under that provision. My lord, what I'm submitting is, my lord, my lord, for a moment, I'm not saying that they don't have the, my lord, the authority which has the power to grant has the power to cancel. Not for a moment saying that they do not have the power. They definitely have the power, my lord, because the authority which grants something, my lord, has the power to take it back also. But under what they have given me.
We are reserving.
Please
consider the arguments of
Consider
both
all.
the sides.
Yes.
But very efficient, very effectively you argued the matter.
Lord,
That's
I'm
what you
grateful
should.
that your lordships you have taken a lot of your lordships time, Lord. I apologize for that.
No. We have learned some laws. I have learned some laws.
Regular order.
Before your lordships, we are learning every day.
Heard. We got the format of result, madam. Format of result. Heard at length, then pleadings are complete. No further are required and result for judgment.
Only request, my lord, is your lordship may balance the equities, my lord. That is in the end, alternate prayer in the end, my lord. That is all that I would request your lordships.
Your lordships, kindly.
Public.
Serial number
Deeply obliged.
62, your lordships. There's some urgency in the matter. Sorry, your lordships. There's some urgency in the matter. "200 employees are working there, your lordships. That's the reason I'm making a mention of this one. At least
Tomorrow there is no bench.
Friday.
Friday, no bench. Tomorrow we can.
Tomorrow, your lordships.
With kind permission.
61, my lord. Put in minimum for 14. That we listed today, but maybe posted for
Thursday, next Thursday.
My lord, serial number 39, where the my lord's allotment of KDB land, my lords. Lords, it was heard, my lords, there was a direction to KVD. Lords, could it be taken up on Tuesday or Wednesday, my lord?
What is the urgency?